Honorable Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Well, good morning. Welcome to the Fourth Circuit, and we'll hear our first case, which is United States versus Washington. Ms. McGuire.
Good morning, may it please the court. Mary McGuire on behalf of Mitchell Washington. Mr. Washington sold a combination of fentanyl and heroin twice. One time was for 0.219 grams, the second time being for 1.22 grams, and back in 2020 was found to be a career offender at the time of his sentencing. At that time, the guidelines called for a range of 151 months to 188 months. The district court granted a downward variance and sentenced Mr. Washington to 96 months. Without the career offender enhancement, Mr. Washington would have been facing a guideline range of 24 to 30 months. In 2022, Mr. Washington filed a motion for compassionate release, arguing that a non-retroactive change in the law allowed him to file for compassionate release because Virginia robbery under Williams no longer qualified as a predicate for the career offender enhancement. The district court found that the 72-month disparity between Mr. Washington's current sentence of 96 months and the applicable guideline range if he were sentenced in 2022 constituted extraordinary and compelling reasons to grant compassionate release. However, the district court denied compassionate release based on the 3553A analysis. This court has made clear in its decisions in Brown, Davis, and the unpublished recent decision in Smith that a district court abuses its discretion when it fails to consider sentencing disparity in the 3553 analysis in compassionate release cases. And while I understand that district courts are not required to address each of the arguments, there has to be evidence in their reasoning that reflects that they've...
The two Davis in the other case, the district court didn't consider it at all, did it?
It did not consider it at all. Here is our position, Your Honor, in the 3553A analysis.
The district court says that an enormous disparity between the sentence received and the sentence he would receive today can support the extraordinary and compelling reasons. Now, granted, that's before he does a specific 3553A, but I don't think you can say that the district court didn't recognize there was a disparity.
Well, I'm sorry if that's how the court interpreted what I said. Clearly, the court found the disparity supported extraordinary and compelling reasons. What I'm saying, Your Honor, is that it has to also then be considered in the 3553A analysis. And there is no evidence on this record that it was considered in the 3553A analysis.
Okay, so the follow-up to that is that we have said, by my count at least twice, and maybe more, that if a district court mentions something in one part of the analysis, we presume that that analysis carries through to the other part of the analysis. And since this district court found that the disparity was literally the extraordinary and compelling reason and talked about it pretty extensively, in that context, why don't we presume that it carried through that analysis? It seems like we've said that at least twice.
Your Honor, I recognize that you've said that, and most recently said it in the Burley decision, which was my case as well. So I'm
But
very...
we said it before Burley, too. I mean, I realize Burley puts a crisp point on it maybe that we hadn't before, but it's not like Burley is the first time we've ever said that.
I understand that, Your Honor, but I think that how this is distinguishable from those cases is in those cases there's some kind of extensive discussion about the sentencing disparity. Here...
There was an extensive discussion. It's when the district court explained that that was the extraordinary and compelling reason that opened the gate to the possibility of compassionate release in the first place.
And I guess it depends how you want to characterize extensive discussion. It's simply one sentence where the court finds that the 72-month disparity is a significant and an extraordinary and compelling reason to grant compassionate release. That's what the court says, especially given the fact that at the time the court considered this motion, Mr. Washington had served already 41 months, which exceeded the 24 to 30-month sentence. However, I still think that what Davis says, and I think the language in Davis is so important, because what Davis says at 659 is that there must be evidence in their reasoning that reflects the argument has been considered. The discretion of the district court is not boundless, and courts can abuse discretion by failing to adequately explain how it weighed the 3553 factors. And in this case, what happened was I recognize...
Maybe I'm misremembering these, but I thought Davis and Brown, at least part of the proposition there was that the district court didn't consider an enormous disparity anywhere, that was just absent from the case. Am I remembering those correctly?
That is true, Your Honor. In that case, there was not the finding of extraordinary and compelling reasons.
Well, but not just the finding, that the district court, literally didn't mention it. Is that right in those cases?
I believe that is an adequate summation of those cases, but I think that what we have to remember is, going back to what this case said in High, is that there is a two-part analysis on these compassionate release cases, okay?
I'm sorry, say the case name again. I just didn't.
I'm sorry, on High. High, Your Honor. And what High says is that you first consider whether there are extraordinary and compelling reasons, and then you do a 3553A analysis. Those are separate steps of the procedure here.
So in our case law, it is true that the opinions have said where the analysis is completed in the first part of the extraordinary and compelling, the analysis need not be repeated in part two in the factor consideration. What strikes me as different here from the previous cases is, in this case, the court considered the disparities and found those, in fact, to be the extraordinary and compelling reason that takes you to the second step. Are there any cases that you know of where the court actually found the sentencing disparity to be extraordinary and compelling and then did not consider that as a factor in the second step?
I do not know of a case to cite to the court on that, Your Honor, but I think that
this is a unique circumstance where, in fact, the disparity is the compelling reason, but then it's never mentioned again in part two.
That's correct. And I think that really what Davis talks about is that you have to at least have something in the record that shows that the court explained how it's weighing these factors. And when you look at the district court's analysis here, which is just 2 pages of this 18-page decision, what it really focuses on is Mr. Washington's prior criminal history, which was known to the court at the time of the original sentencing, but the court never explains why 96 months is appropriate, why 41 months is not appropriate, why 24 to 30 months is not appropriate. And there's nothing in this record that explains the reasoning for how the court got to the decision not to grant compassionate release. And there has to be something in the record that this court can look to determine whether or not the district court abused its discretion or not.
So what if, let me give you this hypo. The district court order is precisely the same as in this case, but with one difference. And it's at the very end of the 3553 analysis. The court has one sentence that says, basically, the court acknowledges, as it has already mentioned in finding extraordinary and compelling reason, that there is a big disparity. However, the court finds that's outweighed by all the factors the court has just identified. Would that satisfy your challenge at that point? That's all, everything else is verbatim the same.
I think that would come close, Your Honor, yes, because it would at least acknowledge that the district court had understood the argument.
I don't understand how that doesn't run
it.
straight into Burley and Moody, where we say that if a district court mentions something earlier, we presume it carries through. This would just be requiring the district court to say, notwithstanding the Fourth Circuit has said, I don't have to say the same thing again, I actually do have to say the same thing again.
Well, it's not simply repeating it twice, Your Honor, but it's acknowledging it within the context of the 3553A factors. And here, sentencing disparity is a factor under 3553A6 that I believe needs to be addressed statutorily within the analysis of 3553A. Here, 3553A is never even mentioned. 353A6 is never mentioned in the analysis of the district court. The district court doesn't even acknowledge in its discussion the disparity. And unlike Burley, I don't believe, and again, Your Honor, I may disagree on this, that there's an extensive discussion of the sentencing disparity in the extraordinary and compelling section here, but there has to be some acknowledgement of how that sentencing disparity impacts those other 3553A factors, whether they're under 3553A, where we talk about the need to promote respect for the law, the need to provide just punishment and afford adequate deterrence, but also we need to look at the 3553A sentencing disparity. It's a statutory factor that is required to be discussed and acknowledged.
Don't our cases say that they're precisely the opposite, that district courts are not required to discuss every one of the factors?
They don't have to tick them off. There doesn't have to be a tick mark under each factor, but there needs to be enough in the record to demonstrate in the reasoning that the district court considered the argument. And here, Your Honor, my position is that there is not enough in this record to show that the district court considered the argument when doing its 3553A analysis in this case. And it's also significant here because at the original sentencing in this case, the district court granted a downward variance to 96 months. So if the court were to look at this record now, the new guidelines would be 24 to 30 months. And so therefore, to substantiate the 96-month sentence that was originally imposed against Mr. Washington in this case, we're talking about a significant...
By the same judge both times.
By the same judge both times, Your Honor, yes. But it would be a significant, a 50-month upward variance or upward departure. And clearly, this case law by this court says when you're talking in sentencing terms and you're considering upward variances and upward departures, the more significant that upward departure or upward variance, the more significant the explanation has to be. And so in this case, the new guideline range for Mr. Washington would be 24 to 30 months, but yet the court seems to let stand a 96-month sentence with no explanation in the 3553A analysis as to why that is the appropriate number. And here, my position is that the court has to explain it, and there has to be enough on this record for this court to understand the reasoning that the district court exercised in this case for not granting compassionate release. And my position is that this record does not support that.
So you've maybe addressed this already, but something you just said surfaced for me. I just have this feeling that this is a substantive reasonableness challenge masquerading as a procedural reasonableness challenge. That the real objection, I have this, although you have not made a substantive reasonableness challenging, it seems to me the tenor of your brief and the tenor of your, that there is actually nothing this district court judge would say that you think could adequately explain this sentence. Would you like to address my feeling that seems to be lurking? Because I just feel like almost all the individual procedural reasonableness arguments run into a brick wall of something this court has already said. And so it feels to me is that this sentence is just too long. What do I do with that?
Well, I think you look at what this court has said in cases like Davis and Brown and talked about the sheer length of the sentence and where this court has said that is something to be considered in the 3553 analysis. And here, in the procedural realm, and here that's exactly what we have. This court did not consider the sheer length and sentence here from somebody serving a 96-month sentence to now what a guideline range would be if he were sentenced today, which is 24 to 30 months. And so therefore, without that analysis, this court, there's not enough in this record to understand the reasoning for why the court comes to this number of 96 months. And there needs to be an explanation of that given the sheer length.
Could I ask you something about what may be an impending mootness issue?
Yes.
Are you aware, is Mr. Washington's projected release date still January 21st, 2026?
Yes, it is, Your Honor.
So if we remand to the district court, what practical effect is that going to have in the world?
Well, I think I'm very much aware of this issue, given the fact that this has lingered for so long. And quite frankly, I think what I would ask the court to do is not only remand the case, but remand it with the specific instructions to grant the motion for compassionate
Because otherwise
release.
time's gonna run.
Otherwise, it doesn't matter for Mr. Washington. Exactly. And if the court doesn't have any further questions for me on this, then I'm happy to reserve the remainder of my time for rebuttal.
Thank you very much.
Thank you.
Mr. Sawyers, you can give us your side.
Good morning, Your Honors, and may it please the Court. Reed Sawyers for the United States. I think Judge Heitens is absolutely correct that this court has recognized that if a district court addresses an argument in the extraordinary and compelling reasons section, this court assumes it did so in the 3553A factors as well. That's Burley, that's Moody. It's recognized repeatedly that this court looks to the record as the whole, to the totality of the record. The Supreme Court in Chavez Mesa says it won't turn a blind eye to the record. But more fundamentally, this case is Judge Heitens' hypothetical, because at JA 186 to 187, the district court, quote, noted that it, quote, considers a guidelines reduction in the overall 3553A analysis, and noted, quote, that Washington has now served more time than his guidelines range would have been if he was sentenced today. So the district court did acknowledge the disparity.
Well, that's not quite the same thing. Saying that he's already served more than his guidelines range is not saying that his current sentence is dramatically longer than his guidelines. I mean, those aren't necessarily the same thing, right?
The district court did not use magic words, but I think...
Well, it's not just magic words. I mean, it's one thing to say you've served, I don't know, a month more than your guidelines range today. It'd be the other thing to say that under this sentence, you're looking at 70 months longer than your guidelines range would be today.
Well, particularly, so these issues can't be perfectly separated, but particularly when we have the extraordinary and compelling reasons analysis, where the district court expressly found that the disparity was 72 months, which is the correct calculation. His analysis in the 3553A section even more clearly demonstrates that he considered the sentencing disparity there. And the district court also acknowledged the defendant's efforts at rehabilitation. He noted that he had mostly good conduct throughout incarceration, that he had family support, that he had loose release plans. That's at JA 186. And contrary to my friend's suggestion, the district court did provide the reasons why a sentence of time served was insufficient and why the 3553A factors did not support, quote, release or any reduction to the sentence. He noted that the defendant's criminal history began at the age of 14. This is on JA 185 to 186. That he committed the instant offense while on probation. That he has a tremendously lengthy criminal history consisting of 30 offenses, including serious offenses such as robbery and grand larceny and resisting arrest and brandishing a firearm. That he would have had a criminal history category of 6 without the career offender enhancement, and that he committed this crime.
Counsel, you've got plenty of time. You can slow down a little bit if you want to.
I'm sorry, Your Honor. And that he committed this crime at the age of 45. So I think the district court's 3553A analysis amply supported its refusal to reduce the sentence, and the district court did address the guidelines range at both the 3553A step and at the extraordinary and compelling reason step.
You know, I asked your colleague the same question. What strikes me as different in this case from our prior cases where we say it's enough to consider a disparity in the context of the extraordinary and compelling analysis, and the district court doesn't need to go back and consider that in the weighing at 3553A stage. But here it's different because it strikes me as a very unusual case where a district court finds a sentencing disparity to be extraordinary and compelling. I could find no other case like it where a court found that the disparity itself was the basis for finding it extraordinary and compelling, and then didn't go on to consider that factor in the weighing. Do you know of a case where that was true?
No, Your Honor, and I would just, at JA 186 to 187, the district court did consider the reality that Washington has now served more time than his guidelines would have been. So he did...
It didn't specifically talk about a sentencing disparity and the change in the rule.
I think there's no other way to read that language other than referring to the disparity that it had identified in the extraordinary and compelling reasons section. And I think that the inference, the assumption that a district court considered something at the 3553A step after discussing it in the extraordinary and compelling reasons step is stronger when the district court finds that to be extraordinary and compelling, because you can You could imagine that if a district court finds something is not extraordinary and compelling, that's minimizing the significance of that factor, and you might think, well, maybe they also didn't consider it in the 3553A step if they have found it's not extraordinary and compelling. But the reality that a district court found that something is extraordinary and compelling makes it only more likely that they would have considered it in the 3553A section. I'd also like to address this idea that the court should remand with instructions to grant. That is not an argument that was advanced by my friend in their opening brief, in their reply brief, so that has been waived. And this is not in the record, but of course, if the court is going to essentially conduct the 3553A analysis for itself, I would note that the defendant incurred a significant disciplinary infraction in 2024. If the court is interested, I can file a 28J on that, but that would further demonstrate.
But that wasn't part of what the district court considered in this case, because that predated that, didn't it?
Yes, Your Honor, and I don't think it's relevant to the analysis we have on appeal, which is essentially whether the district court abused its discretion in explaining its reasoning. But if this court is considering essentially de novo analyzing the 3553A factors for itself and ordering the grant of compassionate release, then I would just note that there's a serious disciplinary infraction last year for using drugs, and that goes to the heart of the 3553A factors, because the mitigation argument is that Washington is a drug addict and can't control himself while he's on drugs.
We're outside the record now.
Yes, Your Honor. If the court has no further questions.
Can I ask you just one? If we were to not do that, if we were to simply send it back for the district court to essentially do the do-over, would the intervening policy statement from the Sentencing Commission, would this be like a resentencing? My question is, the threshold question is, would the updated guidance from the Sentencing Commission apply if we told the district court to do it again?
Yes, Your Honor. This court said that in Davis and in Crawley, which is not cited in our briefs because it postdates our response brief. This court made it even more clear that the policy statement in effect at the time the district court decides a motion for compassionate release.
Well, would this defendant be qualified? I thought they said something about you had to serve a minimum of 10 years to...
Yes, Your Honor. So the policy statement would apply in honor to Judge Hyten's question, and this defendant would not qualify under B6 because he had not served 10 years. And Crawley makes clear that 10 years actually means 10 years, and of course his sentence is only 96 months, 8 years. So he would not qualify under B6. He could try to argue he qualifies under B5, which is sort of the totality of the circumstances, but obviously we would contest that and don't think that he would qualify under B5. So in our view, the district court would not be able to grant compassionate release at the extraordinary and compelling reason step, not to mention the 3553A step.
Thank you very much. Ms. McGuire, you've got some time left.
Thank you, Your Honor. I would just like to address two things very briefly. One, obviously, Your Honor, I appreciate your comments about information outside of the record, and I would ask the court not to consider anything that the government has mentioned about Mr. Washington's conduct in 2024. I don't think
Sure,
that...
but I don't know if we're going to get here, but if you ask us to do the extraordinary thing of not only vacating the district court's decision and telling it to do it again, but to tell it it must grant compassionate release, I mean, I don't know how we cannot consider all the facts. Like, it seemed like you opened the door to that when you asked us to take the step of not simply telling the district court to do a do-over, but foreordaining the result.
Mm-hmm. Well, Your Honor, I think it could be presented at the time if this court, if you choose to remand it and tell the court to reconsider it, we can do it, but by then Mr. Washington's going to be out of jail. I mean, and that's the problem. That's really the problem for Mr. Washington, and we're trying to get some relief for Mr. Washington. And so that is why I have the position that I do. But in terms of the criminal history, which is really something that the government focuses on extensively here, as did the district court, I would just simply note that the criminal history was known to the district court at the time that it sentenced Mr. Washington. Mr. Washington would be a criminal history category 6, whether or not he was a career offender or not. And in fact, the district court knew of Mr. Washington's criminal history when it granted a downward variance from the original guidelines in this case. And so therefore, I believe that the court needs to go beyond that and to look at the entire analysis in the 2 pages that are found at JA 185 and 186 and acknowledge that the 72-month sentencing disparity is not mentioned by the district court at any time during that analysis. And to me, that is where the flaw is, because under 3553A6, the court must consider sentencing disparity in the 3553 analysis. Thank you.
All right. Our note says you're the court-assigned federal public defender, but you're in the Western District.
Yes, Your Honor, but Mr. Washington was...
How did you get the Eastern District?
Yeah, no, I was a assistant federal defender in the Eastern District for 23 years prior to becoming the federal defender in the
Right.
Western District, and Mr. Washington was my client when I was in that office.
So it was a legacy.
Yes.
All right, thank you very much. We appreciate the argument of both counsel. We're now going to come down and greet counsel and go on to our next case. LLC, Mr. McHarg, did I pronounce that correctly?
Yes, Your Honor.
We'll be glad to hear from you.
Thank you, Your Honors, and may it please the Court. My name is Michael Patrick McHarg, Sr. from Kaufman Dulwich, on behalf of Appellant Constellas. This case was a very simple case when it was tried, and it is an even simpler case now that it is before this panel, as we have stripped it down to just a single issue. The rarely litigated, almost novel issue of what is a managerial employee within the National Labor Relations Act. It is a judicially created doctrine designed to separate the problem that labor management relations has of the divided or conflicted loyalty problem between those individuals whose interests are predominantly aligned with management and those individuals whose interests are aligned with the workforce and employees. We need to make sure that those managerial employees in the operation and perfection of their job duties are free from conflict of interest in performing and executing those duties, in this case, in the interest of the security of the nation. It is not an embellishment to say that this case has national security implications.
So is the issue here that there was a wrong definition, or is it whether or not there's substantial evidence to support the lower court decision?
Your Honor, I don't believe that there is substantial evidence to support the lower court's definition, and that is the first prong
But
of our argument.
if we disagreed with that and thought there was substantial evidence, would the case be over then?
If you found that Judge Amchan's decision was supported by substantial evidence, yeah, I believe the case would be over at that point.
So which of the board's specific factual findings are you challenging as unsupported by substantial evidence?
Again, our primary argument is that Judge Amchan chose, for reasons that are fairly obvious, the Wolf nuclear operating case.
I'm not asking about what legal test. I'm asking which factual findings are clearly erroneous. Or not supported by substantial evidence, I'm sorry.
The finding that the ALJ, he discounted the independent judgment exercised by the individual instructors. Also that he found but didn't rely on the fact that Macri and the other instructors did in fact exercise their professional judgment to remove students from class and remove students from training.
So those all may be factors that would potentially show substantial evidence in favor of your client, but it seemed like to me that there were a number of other factual determinations that could be read as substantial evidence in favor of the board. And it's not up to us to reweigh the evidence.
That's correct, Your Honor, but the board itself, the board, as distinguished from the administrative law judge, did not engage in the kind of in-depth analysis or any analysis whatsoever of the judge's finding. They took the very critical cutaway statement that the ALJ, if I were to find otherwise, we would leave them unprotected to petition an employer to ameliorate dangerous working conditions.
The board didn't buy that part, did it?
Well, they said they didn't, but they didn't they didn't do anything to prove they actually.
They didn't adopt it.
They said they didn't
How
adopt
is that
it.
relevant?
They didn't make any single, other than saying, we're not relying on it because they knew it would be troublesome here today. They didn't actually say anything to demonstrate that there was a thought process disavowing that statement. They put in a throwaway statement out of desperation. I don't think that they demonstrated any serious disabusement of that dangerous.
So they weren't disrespectful enough to the ALJ is the idea?
I don't mean to say that, Your Honor. I'm saying they weren't analytical enough to the populace at large to explain what it was they were doing.
Can I take a 20,000 step overview back, which just strikes me as odd about the argument you're making here? So as I understand, the whole thing that gives rise to this entire thing is that Macri and some of his fellow instructors think there's a problem in an area that they work in and that they train people in, right? They're these ricocheting bullets thing, right?
Yes, Your Honor.
And rather than just going and doing what they think needs to be done, they have to lobby people that they're under in the chain of command in order to fix something that directly involves their own workplace. Doesn't that suggest pretty strongly that they are not managers? Because managers, when they see something that's dangerous at their own workplace, just do it. They don't have to try to convince someone above them in the hierarchy to do it, normally speaking, right? It just feels profoundly weird to say that the entire dispute is about these guys who think there's a problem in their workplace within the scope of their area of responsibility, and when they see a problem, they have to convince someone else to do something about it, which to me suggests pretty strongly that these guys aren't managers.
Well, I think that test, Your Honor, I think I understand what you're saying, but
They just don't feel like managers. The facts of this case itself to me sort of illustrate why these guys don't feel like managers.
Well, again, Your Honor, I mean, I'm here because I think it's dangerous to reduce this to what the administrative law judge deemed the layman's test.
No, I agree. I take your point. There's a legal test, but I'm just saying, you're saying that this decision is not just wrong, it is so wrong that we should, notwithstanding a fair amount of deference that's required to the agency here, even post-Loper Bright, at least on factual issues, that we should overturn the agency's judgment in a case where the agency's judgment strikes me as, at minimum, intuitively plausible.
Again, if you put it in a vacuum and say, well, they complained about a serious problem, but the tests have not been, not since Bell Aerospace, the test is not requiring them to participate in full-on managerial deliberations.
Okay, great. So let's take Yeshiva University, because it strikes me that a bunch of your argument in this case is extremely hard to square with what the Supreme Court said in Yeshiva, because they said the fact that this is the footnote 31, which I'm sure you're aware what it says, but it says that professors are not excluded from the NLRA merely because they determine the content of their courses, evaluate their students, and supervise their own research. There has to be something more to make someone a manager. But it seems like a lot of what you're saying are the things that the Supreme Court in Yeshiva says is not enough to make you a manager.
Well, Yeshiva correctly points out that there has to be something more. We think that lagniappe is demonstrated in the training on sexual harassment, which we would all agree is a critical management function. That falls to the instructors. And again, I keep retreating, I will keep retreating to my position. I think there is
Well,
some...
They may be instructing on that and any number of different firearms protocols, but aren't they given all that by their supervising managers?
The initial instructions come from, typically, in my experience, are passed through the employing agency. You know, for instance, the individuals who keep you safe in this building and who put me through security today are employed by a competitor of Constellus. And in the past, in this very building, those U.S. Marshals, Deputy U.S. Marshals, have been Constellus employees. The training in that case initiates with the Marshal Service. And then when it is given to the firearms instructors.
Right, so your folks are told what they're supposed to do.
Initially. Then, the individuals who perform the firearms instruction take their skill and knowledge and conform it to their experience, their training, what they've seen in the real world, whether they were a level 1 operator in Afghanistan.
Wouldn't that be true
or a
of
police
nearly
officer.
every teacher in any setting?
I think it's, no, not necessarily, because I think in the case of Wolf Creek, for instance, the National Regulatory Commission is so hands-on, and as was explained, had 28 very precise points that need to be met for work within a nuclear facility, conditions that don't exist anywhere else in the world, frankly, and there are safety commissions that are so germane only to a nuclear facility that I think that is just a poor analogy. I understand that you could say that it's
Well,
all instructors.
Tell us how this is different, just conceptually. I mean, I know that the subject matter is different, but if you're a high school history teacher, you have certain requirements that you have to teach under the standards of learning and other dictates, but kind of how you do that in the classroom is going to be that's the teacher's prerogative. They're not managerial employees. How are your folks different?
Teaching history, I would be hard-pressed to find a scenario where teaching history was the desired outcome of the enterprise. Whereas here, Constellus is teaching people.
I don't know, the history people might disagree with you on that.
Well, academics would be prone to do so. But the firearms safety, to relegate it to something that is mere common sense is reckless. I'm glad it is not in the real world mere common sense. I think we're all tired of turning on the TV and seeing a 5-year-old shooting a 7-year-old, whatever.
But this comes back to the national security thing that you mentioned in the brief and that you alluded to earlier. Like, that's the argument that what they're teaching is super duper duper important, and let's posit that I'll spot you that it's super duper important, that people who are going to walk around with firearms are adequately trained in how to use them and when to use them. But I don't see how that maps onto the question of whether they're managers or not. Like, the importance of what they're teaching has anything to do with whether they're a manager. But it keeps popping up at various points throughout your argument, so I just wanted to surface it and give you a chance to, if you think it is relevant somehow, I'd like you to try to explain to me why is the importance of the subject being taught relevant to whether someone's a manager?
Because executing the duties of Constellus and its subsidiaries depends upon the proper use and safety of firearms for the safety of the individuals who are within the purview of their coverage on a day-to-day basis, or, God forbid, in those very rare circumstances where there's an
But
emergency.
isn't that just an issue of the qualifications of the employees and not whether or not they exercise managerial obligations or duties?
You get hired because of your qualifications.
And
Constellus,
your employment is presumably maintained because of your qualifications.
that's correct. I believe that. I agree with that statement. What I was going to say, though, is that you're trying to make sure that they're learning. They introduced the SEERT gun. They introduced the blue gun. They drafted the entire curriculum for Maryland wear and carry. These are the interests of the employer. DC Special Police Officer. People in this room know that doesn't mean a security guard. A DC Special Police Officer is a DC police officer, a sworn DC cop. So they're developing the training that helps Constellus's business people sell more services and lets them know that when they want, Constellus to bring out the level 1 operator types, that it is Constellus that has the instructors in the interests of the company to make those training decisions on the fly.
Employees are presumably always acting in the interests of their company. That doesn't make them managers.
Of course not. Of course not. Back to the divided loyalty problem.
This
But
does seem
what
like
if?
an exception that would swallow the rule.
What if you had a labor organization then that negotiated a collective bargaining agreement that prevented firearms instructors from disqualifying people from training and saying that needs to be a decision that's made at another level? I'm out of time, Your Honor.
If you want to finish your answer, go ahead.
Thank you. So I think conversely, if you leave them in where they have to identify these violations and decide who can move on to a federal contract and who cannot, that to me is the pinnacle of a management decision, because they are deciding who gets to wear a gun. And that to me points back to the divided loyalty problem.
All right, thank you very much. You've got some rebuttal time. Mr.
Thank you.
Cantor, we'll be glad to hear from you.
May it please the court, Jared Cantor on behalf of the National Labor Relations Board. Your Honors, obviously much of this case at this point is not in dispute, including, importantly, that Michael Macri engaged in protected concerted activity and that the company essentially now admits it fired him because of that.
Can I ask you about another thing that doesn't really seem to be in dispute? Your brief says that we defer to the board about the meaning of the statute. Is that really true after Loper Bright?
Your Honor, obviously,
About what the I mean, we certainly give them lots of deference about findings of fact and maybe application of law to fact, but do you have some argument about how this statute is like immune from Loper Bright?
obviously we did not brief that at this point. The board certainly has taken the position in other cases, depending on the nature of that case and what the board did in that case, whether the board still is the expert in construing the statute.
Sure, we think it's Skidmore deference, but like, I mean, I don't want to derail your whole argument. What would possibly be the argument that this statute is exempt from Loper-Bright?
Well, Your Honor, a lot of existing Supreme Court cases.
Sure, I mean, it turns out that Loper-Bright disrupted a whole bunch of law. I mean, I imagine the BIA was a little surprised and unhappy to learn that apparently we don't defer to the BIA anymore about the meaning of the Immigration and Nationality Act, despite there were a whole lot of Supreme Court cases saying we owe the BIA tons of deference about what the statute means, and yet, here we are.
Well, Your Honor, I think the point I would make is that Loper-Bright was very clear that all prior cases are statutory stare decisis.
Sure.
The NLRA has almost 90 years of
Sure, so to the extent,
Circuit and Supreme
to the
Court
extent that
precedent.
the board said things in the past that courts deferred to, we still do those things.
Yes.
But I don't know what the argument for going forward that we owe the board any deference at all about legal questions is.
Well, Your Honor, I think then the board.
Well, sorry, any deference other than our Skidmore, the sort of the lower level power to persuade. And look, the board is very expert, and maybe that'll cash out for them in ways that tend to go better for them than for other parts of the government. But I don't know what the possible argument that the board is just immune to Loper-Bright is.
Your Honor, the board has, I hesitate to say immune. I don't think the board would say.
Exempt, not covered by.
I don't know if it would be a matter of not covered by. I think it would very much depend on a specific board decision. Presumably, Your Honor's referring to maybe some new decision, a groundbreaking decision.
Yeah, the board encounters a new issue, and they do their best. And I don't mean to in any way besmirch that they do their best to get the best answer they can. And in a pre-Loper-Bright world, courts would give a lot of deference to that. And in a post-Loper-Bright world, I don't know how courts give any deference to that, beyond our Skidmore deference.
Well, that would be a case of statutory interpretation. Loper-Bright makes clear that agencies still get deference for policymaking. So it would very much depend on a future case. The board
I guess you don't need us to agree that the board gets some sort of Loper-Bright exemption for you to win this case, right?
No, Your Honor.
Okay.
We are, as counsel I think acknowledged, we are dealing with Supreme Court decisions, Yeshiva and Bell Aerospace, that basically have sanctioned definitions or guideposts. Again, this is a judicially approved exclusion from the Act's protections. So we have the language from Yeshiva, we have the language from Bell Aerospace, and of course, board decisions before and after that on the facts. And of course, that's the point I would want to make is, so this case is turning on whether, as the board found, the company failed to prove its defense that Michael Macri was excluded from the Act. And that's a question of substantial evidence. And,
So isn't it, I mean, if there's substantial evidence to support the board's decision, as I ask opposing counsel, that ends this case?
Yes, Your Honor. That is the standard of review. Garden Trucking, a post-Loper decision from this court, articulated it, that the court reviews the NLRB factual findings and application of undisputed law to the facts under the substantial evidence standard. Substantial evidence means more than a scintilla of evidence, but less than a preponderance. And that's the court's decision in Pactel. And I think there seems to be some agreement here that, we should talk about the actual evidence in the case if the court is interested. My counsel, my brother at the bar seems very knowledgeable about guards and where his client provides them. I certainly am very knowledgeable about the record in this specific case and the factual findings made here. And if the court is interested, I am more than happy to go through the board's factual findings and, the evidence that supports them as well as the evidence that detracted from the company's argument or its defense.
Well, why don't you give us an abridged Reader's Digest version of why there's substantial evidence here, so we'll have it.
Sure, Your Honor. Some pieces that really jump out to me in the record because they pertain specifically to Michael Macri. So when you're on the range as an instructor and you're teaching a course, the company has these range cards. They're in the record. They sort of look like note cards that you're supposed to follow. And one day, Michael Macri departed from the order. And he was warned by his team leader, Kellogg, that those have to be followed in the sequence that they are created, that the use of an audible must never occur without prior approval from the management team. Another instance with Michael Macri, in a classroom setting, a student smells of alcohol, he files the spot report, the company decides to send that student home. Student comes back a month later, smells of alcohol again, Michael Macri documents it in a report, the company sends him home, he shows up a couple more months later. Again, he's documenting, he's not taking any action himself. Another incident I thought was very interesting, Michael Macri punished a class because a group of students, because they were late coming to class. The training manager, James, warned him that Michael Macri, as an instructor, was not allowed to impose any punishment of any kind for any reason. His only recourse was to generate a spot report, submit it for review, and management would determine if there would be any further action. That's the type of evidence that I think supports the board's finding here, that Michael Macri was an employee, which again, essentially is the default position. He was working for this company for compensation. The question really is, could the company carry its burden of showing that he was managerial? And on this record, they fell very far short. If there are no further questions, the board rests on its brief.
Thank you very much.
Thank you, Your Honors.
All right, Mr. McCarg, you've got some rebuttal time left.
Briefly, Your Honor, I just would want to respond to the three substantive points that my colleague made. First, I think it's very dangerous in this case. I think, as I mentioned earlier, there were some dangerous things that happened in the analysis in this case, and I think it would be dangerous here to read anything into this idea of, oh, we argued in half of our brief that there was this protected concerted activity. That isn't even, the question is, if he's a managerial employee, there could have been no protected concerted activity. That's putting the cart so far in front of the horse that it's almost like checking the transmission on a horse. And secondly, the examples cited by counsel of the alcohol spot reports and the late to class, as litigated, demonstrated that Constellus guarded its outside of the classroom conduct and differentiated it from the very important job function that it expected from its firearms instructors. It did not want them policing things outside of the classroom, but rather focusing on the critical challenge of getting everybody to meet the firearms standards. With that, there's no questions?
All right, thank you very much. We appreciate the argument of both counsel, and we're going to come down and greet counsel, and we're going to take a very brief recess before going on to the rest of the docket.
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. So we're going to hear argument next in Hernandez versus Bloomingdale's. So, Mr. Etzel?
Good morning. May it please the court. I'm Jameson Etzel for the appellant Marilyn Hernandez. For the exercise of specific personal jurisdiction, the Supreme Court has a very simple two-pronged test. The first prong is that the plaintiff has the prima facie burden of showing the defendant has taken some voluntary action to avail itself of
Well,
the
let
forum.
me ask you first, you've
Yep.
got, as I understand it, there's two defendants here. You have Bloomingdale's LLC, which I assume is the store you walk into, and Bloomingdale's.com, which would be the internet arm. So have you alleged specific personal jurisdiction as to both?
Yes, we allege they're acting together as an integrated retail enterprise. So there really is only one Bloomingdale's. They may have divisions that are,
Okay, but we agree these are separately incorporated entities, right?
as far as I know, yeah. I
And
mean,
have
they're-
you made, or did this court make any findings that we're like going to pierce the corporate veil because they're essentially alter egos?
No, I don't
Okay,
think.
cite one case for me that says you're allowed to do personal jurisdiction analysis that way. You have two separate legal entities, and you say, we'll just mash them together for personal jurisdiction purposes.
Well, we say both defendants did the same thing.
But that's facially, well, first of all, your complaint doesn't really allege that, and second, that just seems to me, like, that almost feels like it flunks Iqbal. The idea that literally every single thing that's mentioned in your complaint was done jointly by both of these separate legal entities.
Right, well, I think it's important to keep in mind that we're at the Rule 12 stage.
Right,
here.
that's
So-
why I
so-
said I think such a suggestion, to the extent you make it, flunks Iqbal.
Well, a plaintiff does not know, as an average person, there's no way to know within the Bloomingdale's enterprise which LLC is
We
responsible
do
for
have
which
things called
activities.
jurisdictional discovery, right? We have things called jurisdictional discovery, don't we?
Sure, and I think if it was going to turn on anything we could find in jurisdictional discovery, I mean, we'd find it. There's no question that they're both engaged in both of these enterprises, which is operating the retail store and operating the website. They're doing both things. Both LLCs are involved in both
All right.
things, both entities.
Hold on a second. So the Bloomingdale's LLC, which you initially said, you agreed with me that that was the physical entity.
Well, I actually don't know that, Your Honor, and I don't think any plaintiff writing a complaint could know that for sure. I mean, when you're filing a complaint, all you know is the website says it's operated by Bloomingdale's LLC. Or you walk into a store, you don't know what technical company within the Bloomingdale's family is actually owner of that store. No one knows that from the outside. You would need jurisdictional discovery to get there.
We also have information and belief allegations, right?
Yeah, but we allege in the complaint that they are both involved in both operations, both corporate
But
entities.
it's not enough to say that they're both involved at some level, because you can't do a specific personal jurisdiction analysis by alleging that two separate legal entities are both involved in the same kinds of things, because these cases often turn very carefully on, like, what exactly did you do? And that's enough for purposeful availment, but this is not enough for purposeful availment. That's enough for nexus, but this is not enough for nexus.
Well-
And so it's not even enough to say that they're both involved at a high level of generality.
If the district court had ruled on any of those grounds, we could have moved to amend the complaint and then looked for jurisdictional discovery. We didn't really get that opportunity because the judge here didn't do any of that type of
Okay,
analysis.
but how about on appeal, where your friend on the other side raises this same argument that they also made before the district court, and as far as I can tell, you literally don't respond? The argument is, you simply can't do personal jurisdiction this way, and as far as I can tell, you literally don't respond to that argument.
I think the good faith reading of the complaint is that we do allege on
But you
information.
don't respond to their legal argument that you cannot do personal jurisdiction analysis this
I
way.
think you can do personal jurisdiction
What case
analysis.
says you can do that?
Well, I'd like to point out the Ninth Circuit, in a case against Bloomingdale's a couple months ago, said They made the exact same argument, and the Ninth Circuit dispensed with it in one sentence. They said the plaintiff alleged they both were engaged in these things, that's enough, we're at Rule 12. If they want to show, and the case is Mikulski, is the plaintiff's name versus Bloomingdale's, a few weeks ago. If they want to challenge personal jurisdiction on the basis of this defendant doesn't do these things, they can raise that type of factual argument, but in the district court, that's not really where this went. This went, all we have is a website, and you can't bring a defendant into a state based on a website. And we said, no, wait. This is a wiretapping case, and we're talking about a defendant that has a physical store here, sells products.
No, we're talking about one defendant.
Two defendants that both operate this store. They're both involved. You can buy products.
Did you bring this case to the attention of the court?
Which case?
The Ninth Circuit case you're talking about?
No, I didn't file a Rule 28J letter,
So
but
your colleague on the other side was not given advance notice that you plan to raise this case at argument?
I suppose not. I
And
don't.
neither was the court?
No, but they were the counsel in that case. They know of it occurring. Some courts.
We weren't.
I apologize for that. Some courts have different approaches to Rule 28J. Some prefer that you don't file things before the argument because you can just talk about them at the argument. And I apologize if I didn't follow the court's preferred method on that.
Well, let me take you in a slightly different direction, and we may very well come back to this multiple defendant point. And this case presents several conceptually difficult issues, so don't be overly concerned about the clock, because we're really controlling the clock. And I'd like to delve into some of these things. So setting aside specific personal jurisdiction, which we will come back to, a court gets essentially to choose how it wishes to proceed if the issues are personal jurisdiction and standing. And I have some degree of difficulty seeing that your client has standing here. And last month, both the Ninth Circuit and the Third Circuit decided these session replay cases, which it seems like what you have, and they said, no, those plaintiffs don't have standing. Why does your client have standing here?
So the client here, this plaintiff has a classic privacy harm, which is the intrusion upon seclusion. It's also related to the type of harm that would traditionally be protected at common law by
Our other circuits didn't
trespass.
seem to buy that.
Yeah, they're incorrect.
Okay, so
say straight.
but that's an important threshold question.
Yes.
Do you think there is any way to distinguish those decisions?
Factually, no, these are basically identical
Okay.
cases. I'll give you that
So
much.
we would, under that circumstance, we would have to say, okay, we're creating a circuit split. These guys are wrong, we're right.
Yeah, and it's good to be on the right side of the circuit split. And the mistake that those courts made is first of all, they're not really following the Supreme Court's test in TransUnion and Spokio. All they're doing is they're going straight to this common law tort, and they're saying, well, on this element of whether it's personal or this element of whether it's an offensive invasion, we don't think you have enough there. They're basically saying you don't state a claim. That's not the way the Supreme Court has said to do this test. You have to look abstractly at the right invoked by the plaintiff, and is it close enough to something that was actionable at common law?
Okay, so let me think of an analogy that seems obvious, which you surely thought of, which is the nosy clerk who follows me around the store and carefully observes every single thing I do while I'm in the store.
That's an analogy that
Seems like a pretty directly on point analogy to me.
I think not, because in that analogy, you're out in public. And here, we're talking, a better analogy is...
But I don't think I'm in public. I think that I have carefully,
Yeah.
to be clear, this is not a hypo where they're peeping in the changing room or something, but like, I've made some, okay, so actually, let's take the Vegas casino analogy. Let's assume that absent being in a bathroom or in a hotel room, that every single place I go in a Vegas casino is crawling with cameras.
Yeah.
And even if I go off into a little vestibule where I think that no one's observing me, in fact, I am being constantly observed. Do you think I have standing then?
Well, I have a view of standing that, yes, you have standing, you might not have a claim. because.
How is that intrusion on my seclusion? I'm in a Vegas casino.
Well, when you go to court, you're invoking that right, and that's what the standing analysis is about. It's about what right you're invoking. It doesn't mean you've stated a claim. It doesn't mean you have a good case. It just means you're tapping into a right that the courts traditionally recognize. That's standing. So standing, this is the point I was making about the Ninth Circuit and the Third Circuit. They went straight to the merits, and they said, well, this wasn't offensive enough, and the data involved isn't personal. This court, I would also like to mention, just a couple weeks ago in the AFT v. Bessem case, which my friends did file as a 28J letter, there's a very good description of what interest is protected by the intrusion upon seclusion harm, and it's the looking.
Before you go there,
Yes.
I want to make sure I'm understanding your argument. You seem to be saying in response to Judge Heitens that as long as I plead whatever the generic argument is, intrusion upon seclusion, I have now established standing.
I think you need to have a fact pattern that shows you're in this ballpark where the defendant did something that arguably is invading that right. So the better analogy, not the public store and not the casino, the better analogy is someone opening your mail or someone literally eavesdropping outside your house. Those are the classic forms of intrusion upon seclusion. They predate technology, but they were certainly actionable. If someone opened my letters without my permission, it doesn't matter what's in those letters. They've invaded my right. Now, back then, that might have been a trespass upon chattels claim. They opened my mail. They interfered with my property, right? But as the 20th century and the new technologies developed, we developed torts like intrusion upon seclusion that take away the element of the physical invasion, because we know now that people can peer into our lives using technology.
What is the specific information that your client alleges was shared with Bloomingdale's through this software?
So it's the fact that she was
It's my understanding it's how she moved her mouse or where she lingered on a particular product.
The fact that she's on the website at all. None of that is any third party's business without her consent, and there's a law that
But
says.
you haven't sued the third party, you've sued, it just seems intuitively challenging to me to say that if I go to someone's website, it intrudes on my seclusion that the people whose website I'm on track what I do on their web. You haven't sued these third parties, you've sued Bloomingdale's.
It's a procurement theory. The injury comes from the fact that a third party is getting real-time access to what you're doing. We're very clear about that in the way we set up these allegations. We're not complaining that Bloomingdale's sees that the plaintiff is on Bloomingdale's website. That doesn't make sense.
That Bloomingdale's
I agree.
obviously is going to know that people are on Bloomingdale's website.
Yes, the problem is there's third parties that are seeing everything, as we allege. This is a very comprehensive collection of data. It's everywhere you move your mouse, everything you type. A third party is getting that in real time without your knowledge. That's the invasion, that's the intrusion, that's the peering, and it's the third party that we don't know about using technology. That's what makes this a classic intrusion.
Do you allege that this third party, who I assume is some sort of an agent then of Bloomingdale's, does something with this other than give it to Bloomingdale's?
We have allegations in there that this is used for marketing purposes. This is used to, I think Bloomingdale's.
Marketing by whom?
Bloomingdale's is the primary beneficiary of the data that they collect, I would assume, but the third party, we don't know exactly everything that they can do with this.
But you haven't alleged that they've done anything with any party other than Bloomingdale's?
We don't have any specific allegations about that, no, but they shouldn't have the data in the first place, is our point, without our consent. There's a legitimate use to this technology, but you need to tell people you're using it, and you need to get their consent.
Well, what would be the difference if Bloomingdale's hired its own group to do this instead of, under your allegations, contracting with a third party? So everything was in-house. Is that all the same?
No, because there's no legal separation of the parties, and I think that is important in the law. Having separate legal parties is a difference. Third-party wiretapping.
Now it's really, really, really important that Bloomingdale's uses a separate legal entity to collect this agency rather than doing it in-house, but it's totally irrelevant that you sued two different companies that were matching together for personal. You seem to be very selective about when it matters that there are different entities involved.
My position on the allegations with respect to the two entities and what they did is that we allege both of them did all of these things in Maryland. That's our allegation. We do use collective nouns. I don't think there's anything wrong with that. Defendants, these two entities did this. That's a factual allegation. They're
No,
free
hold on.
to,
Think about a 1983 case, like a failure to protect or failure to train claim, and the idea is like, I'll just sue like 17 prison guards and then just make all of the allegations after that defendants. And you're like, you can't do that. They're different people who did different things in different places.
But
and
here's-
just because
well-
you define them all as defendants, you can't mash them all together.
I think in this case I can. There's only two, and they are the same company. Bloomingdale's is Bloomingdale's. They can subdivide themselves however they want. There's one Bloomingdale's. It's a brand name. They control the brand. They work together to sell physically and on the internet. I don't think it's a big problem at Rule 12.
Does your complaint include allegations of how the corporate entities are set up? I mean, are you saying well, if it's not in a complaint, it doesn't really make any difference. I mean, we don't know if there's a holding company, whether these are brother-sister corporations or what.
If I may answer, I'm in the
We're
red.
going to give you a little, we got to come back to specific personal jurisdiction.
Yeah, I believe the complaint says that one of the LLCs is, controlled by maybe the Inc. entity. I can look while I'm sitting down and get the
I
specific.
believe at least the
out.
defendant's brief represents that the website is a wholly owned subsidiary of the other company.
Could be. Well, and also you say the website, and again, there's nothing in this record that says this company runs
Sorry,
the
the
website.
corporate entity
Yeah.
known as Bloomingdale's Inc.
Right. So
represents as a wholly owned.
when we're putting together the pleadings, we just don't, we don't know enough to make allegations at that level of granularity.
So why don't you go back and just take a minute to tell us what specific activity does Bloomingdale's direct into Maryland as opposed to all the rest of the Western world?
Well, they have a store here, we allege that. They ship products here, we allege that. And they send the code that caused the wiretapping to the plaintiff's computer while it was in Maryland. So that's an electronic contact directed into the forum, and that's what the claim arose out of. And right there,
Yeah, but your client goes on the website. I mean, the Bloomingdale's didn't come after your client went after Bloomingdale's.
but they came here to do business. And so once people start taking them up on their offer and going to their website to do business, that's it. If a claim arises from that activity, it's fair enough that they face the claim here because
So
they chose to be
Bloomingdale's
here.
had no physical store in Maryland.
If they did not,
If they did not, is that,
that
it's
gets,
your claim?
actually, no, it gets us pretty close to the facts of the Briskin v. Shopify case that the Ninth Circuit decided on Bonk, and they also filed that one. Well, actually, that came while the briefing was still open, so I talked about it in the reply brief.
But how would that not be foreclosed by our opinion in Fidrick?
Fidrick is way factually out of the ballpark here because that was about a claim that happened in Italy, and the plaintiff was trying to sue in South Carolina.
So I agree with you that factually, Fidrick is way out of the ballpark, but
Yep.
Fidrick's and I think there would have been a very easy way to decide Fidrick that has like nothing to say about this case, but it seems like the way we decided Fidrick says quite a bit about this case.
Well,
Not the facts. In other words, I'm not going to be persuaded by you telling me the facts of Fidrick are very different.
Sure.
I agree the facts of Fidrick are super different, and I could imagine an opinion in Fidrick that says nothing about this case. But that's not the opinion we wrote in Fidrick.
yeah, so I think the easiest thing to do is go back to the basics, 2 prongs, purposeful availment, and then the arise out of or relate to activity in the forum prong. Fidrick clearly fails on the second prong, the arise out of prong. The claim didn't happen.
That is not the basis on which this court decided Fidrick. In fact, that's the basis that the court said, we're not going to decide it on that grounds. We're going to decide it on the other grounds.
Well, after that, we've had the Supreme Court's decision in Ford Motor v.
That's not an
Montana.
argument that Fidrick doesn't say that. That's an argument that Fidrick has somehow been abrogated by Ford.
I'm not sure really, Your Honor, you could clarify, like, what aspect of Fidrick do you think speaks to this case in a way that would cause us to lose?
The whole discussion about how the website works and why that isn't purposeful availment, and the fact that I can in Marriott, the fact that I can in South Carolina go on a Marriott website and I can reserve Marriotts all over the world and I can buy things from Marriott, and that Marriott, when I do that, is gathering all kinds of information about me, and that's directing conduct, that Marriott's drop-down menu lists South Carolina, right? That all seems pretty directly germane here.
I think that all, and in this type of case, I think it still shows purposeful availment in South Carolina, even if the court didn't hold that. It goes to it. And here,
I thought our holding in Frederick was there wasn't purposeful availment in South Carolina.
and I think it should have been decided on the
Maybe I
arise
would
out
have
of.
been wrong. If I was on the panel in Frederick, might have agreed with you.
I actually think it's kind of confusing, and it doesn't really make that much sense when the arise out of prong is really where you want to go with that one. But let's bring it back. Let's bring it back. You can have a website, right? It's accessible everywhere. I agree, that alone is not enough. That's not enough of a jurisdictional hook. You need more. Okay, let's look at our case. We have the website, but we also have a store. We have sales into the forum that are both in person and through the
I
website.
thought you just told us a little while ago that you don't need the store to
You
make
don't,
your argument.
under the reasoning in Briskin, which is the Ninth Circuit's en banc decision and is very cogently reasoned, you don't need the physical store, but we do have it here, so why not talk about it? They've availed themselves of Maryland. They want to do business here, physically and electronically. So we're done with that prong. They've availed themselves of Maryland. Let's move on to the arise out of relate to prong. What's this case about? It's about an electronic contact that invaded the plaintiff's privacy in Maryland. It's here, it's located here, it's part of their business, it's part of what they're doing every
The
day.
store didn't avail itself.
The physical store?
No, the store didn't make the contact on her computer and track her comings and goings on the computer, presumably. It was the website. So we're back to the piercing the corporate veil.
Which is
no
part-
allegations in the complaint about that.
It's-
On the issue of standing specifically, are there allegations in your complaint about what specific information your client was disclosed and what happened to that information?
She's-
Not general allegations about what this software does, but specifically about your client and her injury.
She searched for products. That's our allegation.
And that's what they know.
She looked at products on the website. That's what's in the complaint, and that is enough. Anything, you open that letter, you read anything I wrote to someone else without my permission, you've invaded my privacy.
So
At
explain to me
least-
why, you've done the letter. Fair enough. I guess both as a historical matter and as an intuitive matter, I guess I buy the argument you opened my mail. You had a third-party agent keep track of what I did when I was on your website, which I chose to come to. I guess, again, I will say the analogy to opening my mail strikes me as an imperfect at best analogy. Would you like to try to convince me why that's the right analogy here?
It's a good one. How about this? I hired someone to tap your phone. Even though I'm a party to the phone call, I hired my friend to listen in so they could hear as well and report back to me any insights they might have from our conversation together.
And to make that example work.
That's illegal.
To make that example work, we're in a state where it's totally legal, that one-party consent is sufficient. In other words, that I could 100% record the call myself, but it becomes a problem when I hire someone else to do it?
In some states, you only have a one-party consent requirement. In others, you have an all-party consent
No,
requirement.
but I'm just saying, you conceded before that there's nothing wrong with Bloomingdale's knowing where I go on the Bloomingdale's website.
Yeah.
So to make that analogy work, we'd have to assume it's a state in which it's perfectly okay for either side to record, but it becomes a problem when the side that decides to record enlists the help of someone else to do the thing they themselves could
Yeah,
do.
so I think I'll go back to my other point. When we're talking about Article 3 harms, we're talking about the right the plaintiff is invoking. So even in that situation, they might be doing something perfectly legal and they're going to win the case. The plaintiff has standing because they've invoked that right exists. We can debate as the case moves through the merits. Did they state a claim? Is this real? Like, is there a consent defense? Those are things the court deals with once jurisdiction is established. We're at the very opening gate here when we're talking about standing is, has this plaintiff even invoked a right that conceptually exists and has been traditionally protected?
Does that answer your question? All right, we've been pretty generous on time, and we thank you for indulging us there. So you'll have some rebuttal time, and now we'll hear from Mr. Burchard, or Ms. Burchard. Apologies.
Good morning, Your Honors, and may it please the Court. Kendall Burchard for the Bloomingdale's defendants. So you've heard a lot this morning about both personal jurisdiction and standing, but this Court could affirm for either of those bases. I'll start with personal jurisdiction, though, and some of the corrections on the two defendants here. So as this court has said, and as the Supreme Court has said, the personal jurisdiction inquiry turns on an individual defendant's contacts with the form. And here there are two defendants, and they have not alleged facts against both of those defendants separately, simply they've treated them together. We argued below that that was impermissible. That's at JA 46, where the district court recognized that we had made an argument that these defendants should have been treated separately. Importantly, below, the plaintiffs never asked for jurisdictional discovery and eventually added the Bloomingdales.com LLC as a defendant upon amending their complaint.
So is your point here, we made the argument the district court just didn't get to it?
That's right, Your Honor. But just playing to this court's intuition that for personal jurisdiction purposes, the defendants should have been treated separately, and here they were not. I'd like to speak a little bit about the Ninth Circuit's decision in Mikulski as well. My friend on the other side has referenced it, and there the Ninth Circuit, in an unpublished decision, did not entertain the corporate separateness of the two defendants. We would respectfully submit that was an error. Mikulski was also compelled by the Ninth Circuit's decision in Briskin, which is in tension with this court's approach to personal jurisdiction over web-based contacts in particular. As this court has already discussed, Fidrich decides this case, and this court's tests establish an ALS scan. And there, the court is very concerned with specific targeting of the form by these web-based contacts, because that is sufficient to show that a website operator has purposefully availed itself of a form.
So can I ask you what my concern about these cases is? It seems to create a world in which, because you do something everywhere, you're subject to personal jurisdiction nowhere. And I've mentioned earlier, Tay, these sort of, that seems intuitively insane and obviously wrong, right? So could you tell me where you think Bloomingdale's is subject to specific personal jurisdiction for these specific allegations in this complaint? Because if the answer is nowhere, I'm going to suggest that I think something has gone wrong with our theory of specific personal jurisdiction.
So, Your Honor, my friend on the other side has conceded that Ms. Hernandez is proceeding under a procurement theory, and so we would submit that Bloomingdale's would be subject to personal jurisdiction at the place where they procured and embedded the session replay code on the website. That is not alleged within the complaint.
So like the place you'd have to figure, like, so presume this is some sort of contractual arrangement with this third party. So it's like this contract was made somewhere, or this agency relationship was created somewhere, and they'd be subject to specific personal jurisdiction there?
That's right, Your Honor. In addition, Bloomingdales.com and Bloomingdale's LLC would be subject in their places of incorporation and
Sure, that's
principal places of business.
but saying that there's always a place that you're subject to general jurisdiction. I guess what I'll say is the whole idea of specific personal jurisdiction is, general personal jurisdiction is we can sue you for anything there, anywhere, right? And specific is, I don't know, if the stuff you did is connected to this place, you're subject to personal jurisdiction there, even if you wouldn't be subject there for things that aren't connected to the stuff you did. But at least implicit in that, it seems to me, there must be somewhere where you're subject to specific jurisdiction based on the stuff you did.
That's right. And under the plaintiff's procurement theory, that would be where the code was procured and embedded on the Bloomingdale's website.
And you're telling us that I'm not quite, that there's nothing in the complaint that alleges where that happened?
That's correct, Your Honor. That is not included in the complaint. And I think that speaks to the complaint more broadly and the lack of plausible allegations within the complaint. As came through in the court's discussion of standing, Ms. Hernandez has alleged very few things on her interactions on the Bloomingdale's website. At paragraph 61, she says that she visited the Bloomingdale's website, but she doesn't allege anything further. She simply says that she accessed the website and then presumably left the website. And that's insufficient to give her an Article III concrete injury for this case to proceed.
Can I go back to personal jurisdiction for a minute? Although this relates, the same thing here relates to standing. So I am familiar with the argument that you all have. It's basically, they say, we mention embedding in the complaint, and you say, well, yes, but that's not the theory that you relied on to get personal jurisdiction in the district court. And they say, yeah, but we do say in the complaint. So bracket for the moment the question of whether this is adequately preserved, adequately before us. If, let's just say the complaint alleged in crystal clear fashion, I went onto your website and our two little computers had a handshake, and the little handshake does make clear if one wants to know that I'm in Maryland. Right? And after it makes clear that I'm in Maryland, it then sends a little piece of code over to the internet and burrows it into my iPad while I'm in Maryland. That seems like that pretty obviously does establish specific personal jurisdiction in Maryland. Again, I know your argument is they haven't really alleged that, but are you challenging, I know that you're taking issue with whether they've made such a claim on the facts. What I guess I'm trying to figure out is, do you challenge that that claim would work legally?
So if the contention was that Bloomingdale's knew that the plaintiff was in Maryland prior to sending the code, or sent her the code because she was in Maryland, then that would be sufficient for
Because
personal
then
jurisdiction.
Bloomingdale's, I mean, I realize it's a corporate entity, it's inchoate, this is all really happening over computers, but the legal fiction is that Bloomingdale's in that world is deciding to reach out and touch Maryland. And once Bloomingdale's reaches out and touches Maryland, and in a world in which the allegedly unlawful conduct is the doing of that thing, there is a one-to-one correlation between the allegedly unlawful conduct and reaching out, touching Maryland. So we have personal jurisdiction then.
That's right, Your Honor. And both the First Circuit and the Third Circuit, the First Circuit in a case against Bloomingdales.com, put dispositive weight on that knowledge.
Can I then ask, why does it matter that Bloomingdale's, this goes back to my concern about the district court's theory of personal jurisdiction and the First Circuit's theory of personal jurisdiction, is that suggests to me that because they do it, because they are so cavalier that they're willing to do it anywhere, that means they're not subject to personal jurisdiction another way to think about this, imagine their protocol, imagine they were really concerned about sanctions or something, like we need to make absolutely certain that our client isn't, that the customer isn't in Russia, because we'd be violating like sanctions if we did that. So we need to know where the person is, so that we make sure we don't accidentally do business with someone we're legally prohibited from doing. And if they did that, and in the course of doing that learned that you're in Maryland, then they're subject to personal jurisdiction. But because the allegations are, we're so indiscriminate, we don't care where they are. The minute a computer pings our website, we send the code, it literally doesn't matter where the person is. Why does that make it better from a personal jurisdiction standpoint? That sounds like you're targeting the world, because you're making no effort not to target the entire world.
Well, so at least as this court has decided in ALS Scan and then reaffirmed in Fidrich, that simply having a website that is accessible in the form is no reason to assert personal
But not just that
jurisdiction.
it's accessible in the form, it's that you're actively willing to do business with anyone, literally no matter where they are.
That's right, Your Honor. And again, that is comparable to the website at issue in Fidrich, as you discussed earlier. So the Marriott website is interested in doing business wherever someone may be and does business all over the country. Same with Bloomingdale's. Bloomingdale's happily welcomes customers from every state in the country. And that is no reason to exercise personal jurisdiction over its website, in particular because this court has made abundantly clear that a website must be purposefully directed at a forum in order to exercise personal jurisdiction over it. Because if the converse were true, then website operators would be subject to personal jurisdiction everywhere, and that would offend due process.
But if I understand your earlier answer to Judge Heitens, if the complaint contained the allegation that before the plaintiff could access the Bloomingdale's website, Bloomingdale's asked them, whichever Bloomingdale's it was, Bloomingdale's asked the person to identify their state of residence. And so they identify the state of residence as Maryland. And then this source replay code is sent out at that point. Your answer to that hypothetical was that would be sufficient for specific personal jurisdiction.
It likely would be, because that would
Okay.
show a very express aiming of the form and a concerted effort to target the form in a way that is simply not alleged here. She does not allege that Bloomingdale's had any prior knowledge of her location or that it specifically sent code to her because she was in Maryland.
Can I ask you though, doesn't this suggest, if we take this type of conception of how tight it has to be for specific personal jurisdiction, it almost suggests to me that Ford is wrong. Because, right, in Ford, the plaintiffs did not sell the accident-involved vehicle in the forum state, and the one thing I know is that Ford says that is not how we do specific personal jurisdiction, right? What was enough is that Ford, you sell vehicles in this state. It turns out you actually sell the same kind of vehicle in this state. You advertise in this state. It doesn't matter that this specific, like, in other words, why doesn't your analysis and the Fidrich analysis and the First Circuit's analysis actually suggest there wasn't specific personal jurisdiction in Ford?
So a couple responses to that, Your Honor. First, as you highlight, the vehicles that malfunctioned were not sold in the forum. At the same time, in Ford, it mattered that Ford had created a market for that specific type of vehicle in the form. It was the case that they sold other models, that they sold the same sort of model in the form. They advertised those models in the form. They serviced those models in the form. And so everything related back to that physical product. And Judge Hardiman, in the Third Circuit opinion, and Hassan spoke about how that the equivalent here of that physical product would be the website. And it mattered that the website was not advertised at the form. It mattered that the website was not the focus of the defendant's conduct. Like, it all goes back to that physical product and how Ford created a market for that physical product. And here, that's not what we have here.
But if the plaintiff is looking for shoes, a particular kind, and Bloomingdale's has sent those particular shoes to the Bloomingdale's store in Maryland, how is that different from the marketing and supply situation in Ford?
Taking a step back, she hasn't alleged any sort of purchase here.
Right, I understand that, but
And her theory of harm depends solely on accessing the website. So as my friend has conceded, they are proceeding simply on a procurement theory rather than buying anything and being harmed from the physical product. So at the time she accessed the website, her harm was complete. As a result of that, the reason why she was going onto the website, whether she completed a purchase or not, doesn't matter because the harm is tied only to accessing the website. That explains why the in-form sales or the Bloomingdale stores themselves are not related to this litigation, because they are not at all tied to the website.
Can I take you, to go back to the sort of related, that this seems like because they're targeting the world, it's not enough. So keep everything about this case exactly the same, but instead of embedding the code, the allegations, instead what they do, the allegations are, again, no one's saying these are the allegations, much less what actually happens in the world, but say the allegations were that what you do when I go onto your website is you hijack my webcam and you proceed to take a picture of me. I literally go onto your website, and the first thing you do is you hijack my webcam, and you take a picture. And to be clear, you hijack everyone's webcam no matter where they are. You don't care. In fact, you hijack my webcam before you even know what state I'm in. And that suggests that I don't have personal jurisdiction over me because you would massively invade everyone's privacy everywhere. You're not subject to personal jurisdiction anywhere. This just seems really weird to me.
Your Honor, that's a very tough question. It does sound that hypothetical.
Your theory does suggest to me that there would be no personal jurisdiction in Maryland if her allegations were you hijacked my webcam and took a picture of me.
No, Your Honor, I think that does get into standing, though,
Why does your theory of personal jurisdiction not suggest that there's no personal jurisdiction even there?
Our theory of personal jurisdiction is tied to where the tortious conduct occurred, and in your hypothetical, I think we can agree that the tortious conduct would be hijacking the webcam and invading someone's privacy in that way. Here, the tortious conduct that's alleged is the procuring and embedding of the session replay code. That matters because, again, that's where the site of the alleged harm was. And as this court made clear in Khashoggi, any sort of interception theory.
Why isn't the embedding in Maryland? The embedding happened when the embedding is on the computer that has the embedding done to it, right?
No, Your Honor. So that's one important difference in the technology that was at issue in Briskin, and that is alleged here. Session replay code simply operates on an individual's browser, whereas the technology in Briskin dealt with a cookie that was permanently installed on an individual's device. Very different, and in particular, if you're thinking about some sort of physical trespass theory.
Well, you just said a permanently installed. I presume I don't see any plausible reason why you distinguish between a temporary and a permanent cookie, right?
Your Honor,
if you reach out and touch my computer, you reached out and touched my computer. The fact that you then later deleted it doesn't mean that you didn't reach out and touch my computer.
Your Honor, again, this doesn't operate.
No, I'm saying you said permanent. The distinction you're drawing does not depend on the permanent versus temporary nature of the cookie, right?
No, Your Honor, this is also not a cookie. As Ms. Hernandez alleges in her complaint, session replay code is not a cookie that impacts the physical device. this session replay code technology simply operates on the browser. But with my remaining time, I would like to say a little bit more about standing, because she has failed to plead a concrete injury sufficient to confer standing, because she has failed to identify any private information that was collected by the Bloomingdale's website.
If we were to agree with you on standing, and we were to rule on that ground, would it be appropriate for us to remand within, I know that the district court judge in the lower court opinion dismissed with prejudice. Would it be appropriate for us to dismiss without prejudice?
That's right.
Or remand with instruction to dismiss without prejudice?
That's probably right, Your Honor. This court has reaffirmed time and time again that jurisdictional dismissals should be without prejudice because...
In fact, haven't we recently said they have to be without prejudice?
Yes, Your Honor, in an opinion you authored, I believe.
But does that really fix the problem? Because that was the case you're talking about was a personal jurisdiction. So can we all agree the district court was dead wrong to dismiss this case with prejudice because you literally can't dismiss for lack of jurisdiction, for lack of personal jurisdiction with prejudice?
That may have been an error, but for the sake of judicial economy, I think it's worth highlighting that Ms. Hernandez has had an opportunity to amend her complaint before.
This was exactly what Judge Brinkema said in Hefter.
Just to play that out, though, Your Honor, she has had an opportunity to amend. Docket 19 at the district court contains a red line of that amendment. She included many allegations that were intended both to support jurisdiction and standing, and so for the sake of judicial economy.
But it just feels like you'd win on preclusion, because if we affirmed the dismissal for lack of personal jurisdiction and then she refiled, and it said without prejudice, and she refiled, you would just move to dismiss immediately and say this is issue preclusion. There's already a holding that she doesn't have personal jurisdiction.
That's fair, Your Honor. But to round out the discussion of standing, though, I did want to circle back to a couple of things that came out in my friend on the other side's discussion with the court
So
today.
I'm assuming you agree with the Ninth and Third Circuit's decisions last
We
month.
do, Your Honor. Yes, we do. And as Your Honor highlighted, this court would create a circuit split if it were to find standing in these circumstances, because as my friend has conceded, there are no factual differences between these complaints. And indeed, if you look at Ms. Hernandez's complaint, it's even less alleged and less robust than some of the other complaints out there. So at least in POPA, the plaintiff alleged that they had viewed particular merchandise and had added something to their cart. And here, Ms. Hernandez simply alleges that she accessed the website. That's a paragraph.
Could you address your colleague's argument that with respect to those other courts, which we'd have to explain how to say this, but that confuses standing and the merits? That's saying that the person has a bad claim, that maybe they should lose the claim, but that doesn't mean they don't have standing to make the claim. That I understand to be one of their main arguments. What is your response to that?
Your Honor, a couple things. So in TransUnion, the court makes clear that there are two separate inquiries here, both the standing and the merits analysis. At the merits, we'd be looking at the elements of the claim. Here, we are simply looking at whether she has alleged a harm that's similar in kind to harms that were actionable at common law, and she has failed to do that, again, because she has failed to allege any sort of communications with the Bloomingdale's website, let alone any private communications with the Bloomingdale's website. She has no reasonable expectation of privacy in her mouse movements on the Bloomingdale's website, especially as to the website operator. And Judge Heitens, you mentioned earlier the analogy to the store clerk, and that's particularly apt here, as both the 8th and 9th Circuits have held. They've discussed how this session replay code technology and tracking movements around the website is quite similar to a store clerk.
But you're the one who introduced the Fourth Amendment words reasonable expectation of privacy, but the response to that, as I'm sure you thought of, is Carpenter, which is like saying, sure, it's true that in some sense, searching my phone is like searching my wallet, but anyone who lives in the world of the universe of 2025 knows it is not. That's what Carpenter says, right? Why isn't there an equivalent argument here? Sure, the nosy clerk can follow me around, but the nosy clerk gets tired, and the nosy clerk doesn't have unlimited attention, and the nosy clerk is not creating an instantaneous, comprehensive record of every single thing that they've memorized. You're the one who introduced the Fourth Amendment words. Why is that not an argument for why we can't simply import the nosy store clerk?
So, Your Honor, the nosy store clerk is also joined by other patrons in the store, and the movements, an individual's movements, a reasonable consumer does not have any reasonable expectation of privacy in their general movements around the store vis-a-vis the store or vis-a-vis other patrons, and that's the same circumstance here.
So let's just assume for purposes of argument that we were to agree with you on standing. So we dismiss for lack of standing but without prejudice, what happens then in the district court? Does the plaintiff get to amend again? I mean, you can raise whatever arguments you want, that the amendment's futile or whatever. They would be able to address both standing and personal jurisdiction at that point, wouldn't they?
The plaintiff has requested leave to amend if this were to go back. The plaintiff would need to ask the district court for leave to amend. It's also the case that despite asking for an opportunity to amend from this court, the plaintiff has not said that, has not offered any color on what her additional allegations would be. Again, she has had an opportunity to amend previously, and so I am doubtful that she could amend anything else.
Right, but there's no issue raised on appeal with respect to any potential amended complaint.
Apologies, Your Honor. We are discussing the amended complaint, and that's the operative complaint here. I understand.
Right, but I mean, if it goes back and they amend again, we're not discussing anything about some amendment we haven't seen.
That's right, Your Honor.
Okay.
With the court's.
All right, anything else you want? We gave you the other side quite a bit extra time. You got anything else you want to tell us?
Your Honor, I think I've made my points, but thank you for your time today, and we respectfully ask that you affirm. Thank you.
All right, thank you very much. Mr. Etzel, you've got some rebuttal time left.
Thanks. Since I know I went over, I'll try to just keep it short and then only respond to the court's questions. On standing and talking about the nature of the right that we're invoking, I just want to read 2 sentences from this court a few weeks ago in the Besant case. It is not the information obtained, but the knowledge that a third party is engaged in targeted snooping that causes the harm. And then they're quoting a note, a law review note. The harm from an intrusion occurs even when no information is acquired. So I think that's really important. We're talking about a right to exclude people from a private sphere. That's the right we're invoking. We're saying these wiretapping laws protect that sphere. You can have communications safe in the knowledge that no one is using electronic devices to hear what you're talking about with the other party. I don't see any problem in the Supreme Court's Spokio TransUnion decisions. I don't see any disconnect between what they're talking about, a concrete intangible harm being, such as intrusion upon seclusion, and the legislature's right to identify electronic communications as completely protected from outside interference without consent. This is right down the middle of the plate of the type of thing a legislature can do. It can adapt legal protections to changing technology. That's what these wiretapping laws do. They say you cannot listen to someone's phone conversation, period, without their consent. It doesn't matter what they're talking about. It's not the nature of the information that might be obtained by the other person. It's the fact that they're listening without your consent. That's the injury. So that's why we have Article 3 harm here. It's pretty simple. This is a classic privacy injury. It would be actionable in analogous circumstances in other technologies like the mail,
And
like
just to
eavesdropping.
continue with that analogy, to again distinguish, say, TransUnion, and the difference between what you just said there and the I think it was the Fair Credit Reporting Act at issue in TransUnion. I mean,
Yeah.
you could say basically the same thing in TransUnion, which is like, it's really, really, really important that you don't get my credit data wrong. We understand that may not have been action of common law, but and yet we have TransUnion.
Well, but there's a group of plaintiffs that prevailed with standing in TransUnion.
Cool, that's that they did something. Well, I'm not sure that helps you, because the plaintiffs who prevailed in TransUnion are the ones that suggest that TransUnion actually did something with misleading information.
Yeah, they shared it outside. That's a defamation type harm. So that specifically is about an injury you cause by saying something false about someone else, right? And we're not in that type of injury. We're in a different privacy injury, the sphere where you can exclude people from listening to your conversations, even if it's with a merchant, even if it's with a retailer. If I had written a letter to a clerk in 1820 and said, "Sir or madam, please, I would like to order 5 of these, here's my payment enclosed." If someone opened that mail without my permission, they violated my rights. Now, back then, like I said earlier, that'd be a trespass to chattels. But the point is, the law protected that right. There was a protection of that right. And the only thing that's changed is its technology. And so because there wasn't, now today, you don't need a physical invasion, right, to overhear what someone's doing. That's why we have the legislature step in and say, you can't use devices to do the same thing that back in the day you had to actually trespass to do.
If that merchant back in the day had taken the letter that was sent and given it to their accountant for purposes of accounting.
Well, there's no, then there's,
That wouldn't have been, that's
yeah, that's
software.
it's a different fact. It's because that's an after the fact, handing over information after the fact from one person to another. You can tell someone a secret and they can turn around, tell someone else.
What if
Privacy
the-
is
what if-
always.
What if the bookkeeper is the one who opens all the mail for the merchant in 1820?
I mean, if we're going to talk about that, I think there's an implied, like, okay, if you're sending mail to this person, they will do something they need to do for the business of fulfilling your order. They will share your letter with whoever they need to share with to fulfill your order. But these types of companies like Full Story, the session replay provider here, they're not engaged in actually selling products to the plaintiffs on Bloomingdale's website. This is a marketing function and an advertising function and a, whatever else they want to say, website improvement function that they're doing on the back
Right,
end.
but
I'll
the
grant
book-
that.
Hold on, but the
Yep.
bookkeeper there in 1820 is getting the information that the person has sent. How's that any different here that Bloomingdale's is getting the information that your client is sending on the website? They're just using the 21st century equivalent of the bookkeeper to do it.
I think there are factual differences there. The difference here is Full Story is opening the mail. And as far as me, the letter sender goes, I've never seen Full Story in my clerk's shop. I have no idea that's the bookkeeper. They're a third party that's opening the mail while it's on the way.
Right, but when you went to the general store in 1820, you never saw the guy in the back room either.
Yeah, sure, but you could at least see the person you're talking to. If you talk to the desk clerk and then they turn and tell the bookkeeper later, those are different fact patterns. We're talking about real-time interception here. We're talking about a statute that says you cannot use technological devices to intercept electronic communications in transit without consent. I mean, these are wiretapping laws. They've been on the books a long time. They're pretty serious stuff. And all they're doing is protecting a traditional right back in the day. So we could debate the merits. Again, I think that's after the court assumes jurisdiction. You're close enough here. You're talking about a right. And maybe we have some differences in whether it's a good claim or a bad claim, but you've invoked a right that exists. And that's all we really need to show for Article 3 purposes.
All right, thank you very much. We appreciate the argument of all counsel, and we will come down and greet counsel and then move on to our last case. All right, everybody can be seated while counsel is changing. All right, our last case is Martinez versus Bondi. Mr. McKinney.
Good morning. Good morning, Your Honors, and may it please the Court. My name is Jeremy McKinney of the North Carolina Bar. I represent the petitioner Jaime Martinez Martinez, a Mexican national who has called the United States home since he was 15 years old. We are here because the Board of Immigration Appeals committed two fundamental legal errors. First, the board misapplied the false testimony bar located at 8 U.S.C. 1101, subsection F6. Second, the board misapplied its own standard of appellate review. Now, regarding the former, the statute is clear. there must be an affirmative oral misrepresentation under oath, made with the subjective intent of obtaining an immigration benefit. Now, here, the BIA said 3 things on this topic. Number 1, petitioner's explanation that he provided a false name to immigration officials during a border encounter in 2006 is inadequate to explain the omission of his entry into the United States under a specific name. This specific name was Juan Sanchez Cabrera. Number 2, petitioner didn't challenge the fact that he, quote, initially failed to disclose, unquote, his use of another alias. Number 3, and again quoting your honors, we discern no clear error in the immigration judge's determination that petitioner provided false testimony within the meaning of 1101 F6 because he had a subjective intent to deceive in order to obtain immigration benefits, as evidenced by his failure to fully and voluntarily disclose his use of aliases until DHS confronted him with evidence.
So can I take a step? So this essentially, this is the legal category mistake that the board confused with omission with concealment, and they took a statute that only makes it illegal. I'm going to overgeneralize, but broadly speaking, a statute that generally speaking only applies if you lie to the IJ, and treated it as if it also encompassed lying to immigration officials or DHS officials, right? Okay, so that I understand, that's broadly speaking the argument. Can I tell you my biggest concern about that argument is whether it's been exhausted, and could you please tell me where you think you exhausted that argument before the BIA?
Yes, and the petitioner's brief, now I will readily concede that that former counsel spent the majority of the brief's time talking about Nice Chavez, which had come out after this case was heard. So, by the way, this case, Your Honors, was heard after Pereira and before Nice Chavez. It was kind of boxed in the middle there. And so after this extensive discussion, counsel spends one paragraph discussing this issue, and in that, that is where counsel provided the explanation that in 2006, the petitioner acknowledged the encounter in 2006, number 1. Number 2, the petitioner acknowledged that he provided a different name, that he provided a false name. Number 2.
I thought there was at some point in the examination that the petitioner was asked if his application was true and correct in all respects, and he said yes, it was, and that the subsequent evidence about the names that weren't disclosed is contrary to that representation, which was made under oath, and that was the falsity.
Okay, 2 issues with that, Your Honor. Number 1, that question was asked by the immigration judge to the petitioner, and his answer was not yes. His answer was yes, but there are some things in the application that are not correct. Then, if you go about 4 pages later in the transcript, counsel asked the court, basically the immigration judge asked the petitioner's counsel if he wanted his direct testimony to be his affidavit, rest on his affidavit for his direct testimony. Counsel said, not quite, yes for the majority of the direct testimony, but we really need to make some clarifications. One of those clarifications is this 2006 encounter with immigration officials where he did acknowledge that he used a false name.
What about there was one false name, I don't remember which one it was, that didn't come out until there was cross-examination. Is that correct?
Not the existence, Your Honor, of the alias, but the precise name. The precise name, what petitioner's testimony all along was, I know I used a different name. I don't remember the specific name. I know I used a different name. I don't remember, he said that consistently and over, and as a footnote in our opening brief points out, we pointed every page where he was saying that. So it was never a straight, I don't know, without some type of clarification as to what he specifically didn't know. And so what we're getting at here is that.
Can I just take you back to exhaustion, because I just want to make sure I have this?
Of course.
Okay, so is the place you're saying this is exhausted J13, page 5 of his brief to the BIA?
I wish I could readily.
It's the part of the brief that's got the heading, "The immigration judge's decision constitutes a clear misapplication of the false testimony bar to good moral character."
Yes, Your
That's the
Honor.
relevant page of the brief?
Yes,
And
yes.
just, is there, I understand you don't have to provide you, but I guess is there any other place that you allege this was exhausted?
No,
Okay.
no. And somewhat off topic, but in terms of the procedural history of this case, there is a motion to reopen pending before the Board of Immigration Appeals. We had originally asked for this to be held in abeyance pending that decision. The government opposed that, and this court denied it, and that's why we're here today.
Can we talk about that motion for a minute, because I know that there is a pending and effective assistance of counsel claim, is that right? What's the status of that?
Your Honor, we have not heard anything from the board since we filed it. It remains pending.
And would that resolve the entire case if that was granted?
It would, like
Would
this.
that moot out this case?
It would moot out this case because there would be a new hearing if that were granted.
And is it still your position that this case should be held in abeyance pending the resolution of that case?
At this point, at this stage, we would rely on the discretion of the court. At this stage, at the point that we.
Right, but the petitioner's your client, so I think, you need to give us a more direct answer than that.
I think that the errors in this case are so grave that we can move ahead with this one without taking it, without leaving it in abeyance at this point. However, if the court were to conclude that abeyance is more appropriate at this point, of course, we understand that because there's a substantial amount of merit to that motion to reopen that we filed.
It just seems in the interest of judicial economy, we shouldn't reach an issue that we don't have to reach if there's another pending proceeding that would resolve the entire case.
There is, except for, Your Honor, in this case, whether counsel engaged in ineffective assistance of counsel does not do anything to shield the fact that the agency made some pretty fundamental errors here. And so having the guidance of this court to say two things. Number one, that concealment is not testimony. The Supreme Court established that in the 1980s in the Kungas case. And number two, if you are going to find that the petitioner had a subjective intent to deceive to obtain immigration benefits, then you can't just cite the governing standard. You actually need to explain how this specific, in this case it's concealment, but let's just call it testimony, how this specific testimony was made with the intent to subjectively, or the subjective intent to deceive, when on its face, that makes no sense.
I understand your argument, but essentially you're asking us to give an advisory opinion to the BIA when in fact the BIA made the same day issue a ruling saying ineffective assistance of counsel and send the case back. Is that, it could hypothetically happen on the same day?
Well, it certainly wouldn't be, if it happened on the same day, then it still doesn't take away the fact that this actual error of law occurred.
So to put
So
it-
is the ineffective assistance of counsel claim part of the motion to reopen, or are they two separate things?
Your Honor, it is the same. And we are asking for the case to be reopened based on ineffective assistance of counsel.
To
Now,
reopen, like, do it all over again to decide whether he's going to get the underlying benefits he's seeking and whether it's barred by the false testimony bar, like, basically a redo of everything we've done.
a redo of everything you've done, and the reason for that.
Is the ineffective assistance of counsel the sole ground in the motion to reopen?
it is the sole ground in the motion because what happened in that case relates to the last part of our briefing here, and that's about the potential due process problems. Number one, they weren't exhausted. The due process element of this not only was not exhausted by former counsel, but he didn't object, raise it, push back with all of the due process problems, the lack of neutrality from the immigration judge that was clearly happening during the hearing.
So is all the briefing done in the motion to reopen?
DHS, to my knowledge, did not submit any response.
So you're just waiting for a ruling on the motion to reopen?
That is correct, Your Honor.
Okay.
And what's the status of your client currently? Is your client in custody?
My client is not in custody. He was provided a bond during the initial apprehension and arrest, and has complied with the conditions of his release. The decision that you may have heard about, Your Honors, that was released last Friday from the Board of Immigration a judge does not have jurisdiction to grant a bond if the person crossed into the United States without inspection, is not retroactive, and so my client should remain out on the conditions of his release.
But is there an actual order of deportation in this case?
Oh, you're exactly right, Your Honor.
Well,
Yes.
no, I'm asking the question.
No, there is. This is currently an administratively final order of removal. In the past, we've had clients actually get physically removed, and then we had to facilitate their return. That has not happened in this case, Your Honors. I do want to, again, address I don't want to look over the second fundamental error here, which was that the board misapplied its own standard of appellate review. What you see over and over in the board's decision is that it was reviewing for clear error. But whether established facts amount to false testimony is not a factual finding. It's a mixed question of law and fact. The BIA owed de novo review on that legal question.
But what's the legal, so for example, do we agree? So at some point, your client had a conversation with the immigration authorities, and there were things that were said during that conversation. To the extent the IJ made a finding about what was actually said during that conversation, that's unreviewable, right?
Unreviewable.
To the extent the IJ made a finding about what your client understood the officer's question to be asking, that's also unreviewable, right? What was in his head?
Correct. At the circuit court stage,
Unreviewable.
Unreviewable. At the board stage, which again is the error.
Is reviewable for clear error.
Is reviewable for clear.
Right. Well, no, you would agree that even at the board, that's reviewed for clear error. Like what's in his head is reviewed for clear error.
Yes, I think that in a line of cases where the Supreme Court has said due diligence is a mixed question, exceptional, extremely, and unusual hardship is a mixed question, torture is a mixed question.
Sure.
It has gotten confusing to practitioners.
It has.
Because I do think that when intent is part of the governing standard, it makes it a little complicated. Because, for example, with false testimony.
Let me ask you this. To the extent that the IJ, I'm not saying the IJ made this finding, but to the extent an IJ made such a finding and said, I have listened to all the evidence, and I am finding that you knew full well what question you were being asked. And I am finding that you deliberately said something you knew was not true. That is a factual finding reviewed by the BIA for clear error and by us not at all, right?
It would be, to the extent that you are reviewing the actual factual finding, I completely agree that it would be unreviewable. However, that's when we need to look at Cortez, which this court issued after Wilkinson. And we have to look at the procedure involved in reaching that finding. And I think there, this court does have jurisdiction to look at that
Well,
and
that
should exercise
Procedurally
that.
is a different question. I mean, I thought that Supreme Court case, Canungus, or however you pronounce it, held that the finding of subjective intent is a factual question.
It did.
Okay.
It did. And again, what I would say to that, Your Honor, is that we've seen in this particular area specifically, we've seen a lot of development in this mixed question. For example, if you look back at a case of my own from 2013 called Garcia, that was cited by Judge Richardson in Ibarra, everything was essentially reviewed for substantial evidence. There really wasn't much of a distinction between fact and law unless it was really super clear that it was a legal question, like in Jean versus Gonzalez. We've seen a lot of changes in this area over the last decade. And I think that this case kind of heightens that, where this court still has jurisdiction to make sure that the agency is going about its fact-finding in a correct and procedurally sound manner, in a manner that's consistent with due process. Thank you, Your Honor.
All right, you've got some rebuttal time. Ms. Freyer, give us your view of things.
Good morning, Your Honors, and may it please the Court, Allison Freyer for the Attorney General. In this case, the Court lacks jurisdiction over both the agency's good moral character determination and the agency's separate discretionary determination that Mr. Martinez did not deserve a positive exercise of grace, and therefore the petition for review should be dismissed.
Before we get into that, can I just ask you, do you have any information to report about the status of his motion to reopen?
Only that it remains pending,
And for how long has it been pending?
about 18 months.
Do you have a sense of how long generally motions to reopen remain pending before the BIA?
Not at this time. My generalized understanding was from before.
A different time?
Yes.
Okay.
But it used to.
And then I think my only last question about this is, do you have a sense of like what percentage of non-citizens in removal proceedings who lose before the BIA file motions to reopen? It is my sense it is a large number of them.
Yes, especially, my perspective is only those who also then file petitions for review, because
Sure.
if they don't do that, then obviously I never see them. But I would say it's more than half. It's not 100%, but more than half.
But it's not uncommon.
Oh, correct, not at all uncommon. There's a lot of procedural requirements that must be met, especially with an IAC claim. And I imagine it will be difficult to overcome the discretionary denial of cancellation here on an ineffective assistance of counsel claim, where the IJ denied exercise overall in the exercise of his discretion based on the criminal conduct that Mr. Martinez engaged in, as well as his conduct during the removal proceedings, which obviously didn't arise from representation, or it would be difficult to link those two, I would think. So there's no jurisdiction over the agency's findings of fact underlying the good moral character determination. The Supreme Court has said in both Kungas and Patel that whether testimony is truthful is a factual finding that this court cannot review. Similarly, in Kungas, the Supreme Court said that the subjective intent with which the alien offers that testimony is a question of fact, and that resolves the question under Patel, and this court cannot review it.
So can I ask, you're going to respond with exhaustion? I'm aware of the exhaustion argument.
I am.
So let's posit exhaustion's off the table for a second.
Okay.
But his argument that the BIA confused an omission with false testimony, that would be a legal question, right?
It would.
If properly exhausted, that would be a legal question.
Yes.
That this court would have jurisdiction to review.
Had he raised it to the board, yes.
Okay. What about, and it seems to me that also under our precedent, to the argument is, I agree, we don't have jurisdiction to second guess the IJ and the BIA's factual findings, but we conclude that the BIA basically didn't do the right process. The argument that the BIA misapplied the clear error standard of review, because, and again, imagine, look, let's do a really simple example. Let's say the BIA said, we find no clear error because, this is the important part in this hypothetical BI analysis, because we cannot say beyond a shadow of the doubt that the IJ was wrong. And the argument is like, that is not what clear error means. So to the extent the BIA did that, we would have jurisdiction to review that. Even if we couldn't review the underlying findings, we could review the BIA has misunderstood how clear error review works.
That's correct. Even after Patel, this court has considered and sometimes granted the PFR where the alien raises the claim that the board applied the wrong legal standard or legal test. Yes. But here the board did not do that because it was reviewing the factual determinations of the IJ. So the clear error standard was the correct standard to use, and in fact the one required by regulations.
But what about the argument that your friend on the other side raises that's based on this court's precedent that says the BIA has to provide like a reasoned explanation? They can't just say that in response to an argument that the IJ committed clear error, the BIA cannot simply say, we find no clear error. And then the listener thinks, why? And the BIA is like, I don't have to tell you that.
The board,
You agree that we would have jurisdiction to review that too, because then the BIA has not provided a reasoned explanation. Like simply saying we find no clear error is not a reasoned explanation.
that would be correct, yes. That's not what happened here.
No, but that would be, right?
It would
Okay.
be, yes. But here, the board did provide a reasoned explanation. So Mr. Martinez has never offered an explanation for his failure to list one of the aliases, Vicente Martinez, on his...
Is that an omission, failure to list?
It is until you testify under oath that your application is complete and correct and that your affidavit is complete and correct, and those things don't say it.
But didn't he say it's complete and correct, except there are some things that are not exactly right?
Yes, and then there was a pause in the hearing, and Mr. Martinez and his counsel worked together to correct the application, and then they came back and he swore that the contents of the recently amended application were complete and correct. And at that point where he says, yes, here, I have it right here, the record at 121, the IJ asks, and is everything you've stated in this affidavit the truth, sir? He says, yes.
So that's the oral statement that you're alleging is false testimony?
Correct, and he says it again on the page before. And so,
So when did there was one other alias that had not been disclosed previously, is that correct?
Correct.
And this came chronologically after what you just read?
correct.
Okay.
He's used 3 aliases in his years in the United States, 1 to work, and that was listed on the cancellation application. 1 at the border in April 2006, that was not listed on his cancellation application or affidavit, but was mentioned at the very close of his direct testimony. And another at the border in June 2006 that didn't come up until DHS presented him with evidence. And at no point did Mr. Martinez affirmatively say, there was another encounter at the border where I used an alias, but I can't remember what name I gave. I've said so many names over the years, I can't remember what name I gave in June 2006.
So again, that's an omission.
It is,
You just said at no point did he say. I think that's the definition of an omission.
that's true. But when he's asked to list all the aliases he's used, listing fewer than all of them becomes a deliberate misrepresentation. An omission or a concealment is where if no one had ever asked him about additional names, then it would not be false testimony under 1101F6 if he didn't provide them.
So can we look at his actual application?
Yes.
This is 624.
Oh,
I think it's the page I'm looking at says J624.
sorry, this one's a big one. Yes.
No, this is, and let me preface this by, I was a government lawyer once, and I had to deal with confusing, badly written government forms sometimes when I was a government lawyer. So question 15, I have been known by these additional names. That's what it actually says. And it doesn't even actually say list every name you've ever used. But let's posit for the sake of argument that probably that's best interpreted to mean list all of them, even though that's not actually what it says, for reasons that I'm sure are complicated and path-dependent about this form. But so imagine a world in which that his testimony at the hearing is true, which is that he did subjectively know that he'd used another name other than Jaime Martinez Hernandez. But when he filled out this form, he did not remember what that other name was. And I'm looking at question 15. It says, I have been known by these additional names. If a non-citizen genuinely knew they'd used another name, but genuinely couldn't remember it, how are they supposed to fill out field 15? Because it doesn't say if there are names you can't think of, you should mention that too. It doesn't say that. It says, I have been known by.
But it also doesn't say, if you can't remember the exact name, don't bother telling us. I think that someone who was honestly, genuinely trying to be fully honest would list their use of an alias, but I can't remember.
That's not the legal standard. The legal standard is whether, so the question that the IJ asked at the hearing is everything you said in your application true, not does it reflect what your mother taught you would be ideal behavior in all situations of like, just in case anybody might be misled or confused, I should say in the interest of full disclosure that. That's not what this form says.
No.
And that's also not the legal standard for false testimony, right?
That's right. But, so I mentioned that not because that's the false testimony, but because it's indicative of the good moral character, which is, after all, where we're driving with this. But the important part is that the IJ asked if everything was true. He said it was, and as he...
And the IJ did not follow it up. Did you leave out anything that in the interest of full disclosure you probably should... The IJ did not follow up with that question. Right?
No, and he didn't have to. And then later in the hearing, Mr. Martinez testified that when he told the IJ everything was complete and correct, that was not true. He told the IJ that he had previously given untrue statements under oath previously in the hearing that same day. So it's not really in dispute that Mr. Martinez provided false testimony. Mr. Martinez simply says that it's understandable because he couldn't remember the use of this name. But that's also not the legal standard. You can give false testimony if it's understandable that you forgot the details. You need to answer the questions accurately and completely. And Mr. Martinez conceded on the stand that he didn't do that when he answered the IJ's question about the accuracy of his application.
Where does it say on this form I have to be accurate and complete? I definitely can't lie on this form. Let's posit that I agree with you, that I definitely can't lie on this form. But where does it say that I have to include everything that might possibly be relevant?
I swear, or on JA 631, the part where the alien signs it in front of the IJ. It says, they are all true to the best of my knowledge, taking into account the corrections that were numbered. So he's affirming by signing it that it is true, and then out loud he confirms that everything in the affidavit is the truth, but he's not but it's not true to act like you've used one name when you didn't. And he acts like
Acting like is not
I
a
know.
false statement.
I hear
So
it.
just getting back to your false statement, there was one statement that you said was the basis of your whole argument, that there was a false statement. Is that the same statement that the BIA relied on in its decision?
I think, yes.
Where?
The board is saying, the board is affirming the IJ's decision, right? So they kind of need to be read together because the board is
But
affirming.
it didn't explicitly adopt it. So I think we're limited to reviewing just the BIA decision unless it explicitly adopts the IJ decision.
The phrase I've seen is adopt or affirm. So where the board is affirming a portion of the IJ's decision, this court can look through the board's decision to the IJ's decision without requiring actual adoption.
So your position is that we're reviewing both?
Yes, because of the review under clear error, that's what makes the most sense. You can't, it would be difficult to look, well, really, you shouldn't be reviewing anything because of the jurisdictional argument, but if you get down into it, yes, you would have to look through the board's decision to the IJ's decision to support the board's decision where the board is doing clear error review. So the board is saying on probably JA 3 or 4, the second page of the board's decision, the first full paragraph right in the middle, the respondent does not establish clear error in the IJ's finding that he omitted aliases and provided inconsistent testimony regarding his dates of entry into the United States.
Where's the statement? Omitted, again, omitted.
Oh, yeah, that's a,
Inconsistent testimony. Where is this false statement? Where is the BIA saying there is a false statement? And what is that statement?
so part of this, I think, is a mark of petitioner's failure to exhaust his concealment argument. Because the board wasn't aware that the petitioner was challenging the IJ's articulation of the false testimony bar or something like that, because the board wasn't aware of where this case was going to go later, they didn't respond to that. So I think some of the reason the board did their decision this way was a mark of petitioner's failure to exhaust. They were affirming the IJ's decision and responding to the arguments made before them, which is all we can ask. So I agree, though, it doesn't say exactly what the false statement was.
Even if we assume, which I'm not sure I agree, that we review both the BIA and the IJ, and even if we assume, which I'm not sure I agree, that there was a failure to exhaust, going back to the IJ's decision then, where is that false statement? Rather than a concealment or I'm confused.
The board's, well, first off, the "I'm confused" statement is,
That's not a false statement.
the IJ says it is.
Where is the false statement?
Okay, so the false statement in the IJ decision is at IJ 6. 1, 2, 3, 4. Sorry, I can find that in the record.
I see specifically as failure to disclose.
Yeah, so the 1, 2, 3,
The material fact was not disclosed.
the paragraph above, the court finds the respondent failed to disclose all his prior entries. I know it uses that phraseology, but when you're saying it's complete and it's not, that becomes the lie. It's not a case of no one asked him, so he didn't tell him. Where you're asking for the complete answer and you give only part of it, that's more than failure to disclose. For example, the IJ once asked petitioner, did you use a different name to work? And he says, yes, I used the name Jaime Martinez Hernandez. That would not be a false statement, even though there were other aliases waiting in the wings, because the question had been, did you use another alias, did you use an alias to work? And he says yes and provides it. So that is the sort of failure to disclose that would not be the false testimony. But where you're asking for everything and you only give part of it, that's when it becomes an affirmative misstatement. And the thing
So you're asking us to find that if a IJ or the BIA says that there was a failure to disclose, that that is a false statement. That seems to run directly contradictory to what the Supreme Court has said, that you need an affirmative statement.
You do, but here the affirmative statement is, I've told you everything, when that's not true. So it would not always be
That's
true.
fine, if that's what the IJ based the decision on.
Yes.
I don't see that anywhere in the decision. That's your argument, it's not here.
Yes. I think we may have to agree to disagree on that. I do see it here, but
Can you show me where?
the IJ says, the court finds that the respondent failed to disclose all of his prior entries into the U.S. and use of additional names as required on the application for relief and in response to specific questions during testimony under oath. So when he's saying that he when he's saying that he said everything and he didn't, that's the false testimony. That's our argument anyway. But in any event, the concealment definitely was not exhausted. So the brief to the board.
So let's talk about that. I have
Yeah.
the brief to the board in front of me. I'm looking at an argument heading that says, the immigration judge's decision constitutes a clear misapplication of the false testimony bar to good moral character. You don't think that's broad enough to encompass this claim?
No, not that the IJ improperly relied on concealment or failure to disclose rather than an affirmative lie under oath, particularly where the paragraphs below, there's some boilerplate, but then the main.
Well, hold on. One of those you're going to skip, because paragraph 2 says, for purposes of the INA, false testimony is limited to, quote, oral statements made under oath with a subjective benefit, and then cites the Supreme Court. Right.
Yes. And
So that's the correct legal standard.
That is, but that part, I think it's the next sentence, but there's a next part in Kungas that says failure to disclose is not enough, but it's not quoted here in this brief. And the next sentence says that inaccurate testimony resulting from poor memory or mistake do not constitute false testimony, and that's the part that's picked up in the next paragraph, that's the application. It's about, I just forgot the final alias.
Can I ask you a question that must come up literally all the time, but I realize, and this is genuinely a question because I don't know the answer to this. What if the non-citizen's assertion is the BIA made a mistake? Not the IJ made a mistake, the BIA made a mistake. And then we come before this court and the government says you didn't exhaust it. And then we say, I did not know the BIA was going to make a mistake. It's a little hard for me to exhaust a claim that the BIA made to make a mistake that I didn't know. How does that work in the exhaustion context?
So that's actually Santos Zachariah, a Supreme Court case recently, in which the board allegedly made an error, and the alien brought it up before the Fifth Circuit Court of Appeals, and the Fifth Circuit said that it wasn't exhausted because you had to file a motion back before the board.
And I thought we said you don't have to do that.
Yeah, the Supreme Court said.
It's like if the BIA just comes in and makes a mistake, how am I supposed to exhaust the argument that you made a mistake in resolving my case?
Exactly. So where the board introduces the alleged error, the proper forum to raise that in would be this court. It's where you're complaining about something that the IJ did and that the board has the power to correct. So you don't have to raise some kind of a equal protection claim or something like that before the board because they can't rule on the constitutionality of the statute. That can wait until the Court of Appeals. But anything that the board has the power to correct must be raised to them.
And so help me understand how, so if he were to, if he were to try to argue someone were inclined to think that, well, to the extent that the IJ made this conflation mistake, the BIA also made this conflation mistake. Because I will say, when I read the BIA's decision, it also looks like it's conflating a false testimony with an omission. What would be your argument for what, like, so what, respond to the following argument. Of course this is exhausted. His argument before us is that the BIA conflated two things that are different. I don't have to exhaust that. What's your response to that?
Because the board is affirming the IJ's decision, the error would have been introduced by, if there were one, the error would have been introduced by the IJ finding those two things. And the board would have been able to say, had it been properly apprised of the argument and if it agreed, that this was concealment rather than an affirmative misstatement, and so needed to, could send it back to the IJ for a new hearing. The important thing to remember is that at the time petitioner was testifying, these dates and entries were critical to his eligibility, because at the time he had to show 10 years of physical presence from the date he got his notice of hearing. And these entries that he was difficult in testifying about, the entries and the names and everything, they all fell within that window. So that's part of what's motivating the IJ here, I think.
Okay, thank you very much. Mr. McKinney, you've got a couple minutes left.
Thank you again. I just want to make three brief points. First, to Judge Berner's question, the standard is affirm and adopt. It is affirm and adopt. And Judge, and I apologize, Your Honors, because this opinion just came out last week, but Judge Wynn really digs into this in an immigration case that was published by this court last week, where he talks about that. And so basically what Judge Wynn was saying is, okay, we may need to consult with the immigration judge's decision because there's some gaps here in trying to figure out what the agency was saying. But if you're talking about things that the board did not really go into at all, we don't consult the immigration judge's decision on that. So it's not just affirm, it's affirm and adopt, and there was no adoption in this case. Number two, it is
that'll often be the case in the clear error context, right? Because the board's going to say, we find no clear error with the IJ said. I mean, it seems like we will almost inevitably have to look at what the IJ said to figure out if the BIA got the clear error standard wrong, right?
Correct.
Okay.
Yes. And here, we've got to actually go with what the agency said. The immigration judge, the Board of Immigration Appeals, and my friend here, they all use different versions of didn't say, failed to disclose, because, Your Honors, his testimony was actually truthful. He did acknowledge that the critical legal issue here, I would agree with my friend, is whether he disrupted his continuous physical presence. How does he accomplish that by not knowing whether he said his name was Jaime or Juan, when he acknowledged that I did leave in 2006? I did leave. I was encountered by immigration authorities, and I gave a false name. And what they're hanging their hat on here is that he didn't know whether he used the name Juan or not, when the 42B form itself does not address that precise question. There is no false testimony here, which is why they have to resort to omission. And the Supreme Court has made clear that that's not good enough. I want to close with the second part of false testimony, and that is In Patel, whether we agree with it or not, the immigration judge identified a motive, that the guy had checked U.S. citizen on a driver's license form to get a Georgia driver's license. There is no motive identified here, and what they did instead was create a tautology. He had an intent to deceive because he deceived. Again, thank you so much for your time.
All right, thank you very much. I want to ask the clerk to adjourn us for the day, and we'll come down and greet council.
The Honorable Court stands adjourned until this afternoon. God save the United States and this Honorable Court.